the program. Please doubly check your cell phone so that your cell phone does not ring when the program commences. So today's program will be divided into 4 sessions. The first session, that is just now the session will start, it will be inaugural session. After that, we'll have 3 technical sessions. In the first session, we'll have Honorable Justice Srimati Soni Srivastava, who will be heading this whole session. We'll have a speaker in the form of Dr. A. Nagratna. The second and third session will be respectively held after that. So before we start, before the honorable guests arrive, I'd just like to give you a brief overview of what the program is all about. The digital age in which we are has transformed not only the way we communicate, but has also transformed the way law is implemented. In this era, we are seeing a surge in cybercrime and electronic evidence. Understanding the nuances of electronic evidence, the digital footprint which is created, how it is to be preserved, how it is to be presented in the court, especially for the police officers, and how the judicial officers and the judges will analyze that electronic footprint, that becomes very essential for all of us. So in these 3 sessions, technical sessions, we'll look into all these matters. The inaugural session will start with a welcome address by Honorable Mr. Justice P.B. Bhajantri, Judge cum JD 2, cum Chairman, Bihar Judicial Academy. And that will be followed by an address by Honorable Mr. Justice Vipul M. Pancholi, Judge cum JD 1, Patna High Court, followed by presidential address by Honorable Mr. Justice Asutosh Kumar, the Acting Chief Justice cum Patron-in-Chief of Bihar Judicial Academy. So we are eagerly awaiting our guests to come. And I'll make a request that when our honorable guests come, please do stand up in their honor. Thank you. Thank you very much for this patient listening. Charlie?
आप कुछ ऐसा नहीं पढ़े ना जो लाइव में जाना था कि आप जब बोलना स्टार्ट किए तब लाइव हुआ सेशन.
Respected guests are requested to ensure that the movement takes place, least movement takes place when the program is started. Please ensure that the movement does not disturb the function. Respected participants, our guests. Pranam and a very good morning to all the honorable dignitaries. Honorable the Acting Chief Justice cum Patron-in-Chief of Bihar Judicial Academy, Honorable Mr. Justice Ashutosh Kumar, Honorable Mr. Justice Vipul M. Pancholi, Judge cum JED 1, Patna High Court, Honorable Mr. Justice P.B. Bajantari, Judge cum JED 2, Patna High Court, cum Chairman, Bihar Judicial Academy, Honorable Judges, Patna High Court cum Patron, Bihar Judicial Academy, our esteemed resource persons, respected Registrar General Sir and members of the Registry, respected Director Sir and members of the Directorate Bihar Judicial Academy, Member Secretary and officers of BSLSA, Principal District and Sessions Judges from all over Bihar, and all the participant judicial officers, police officers, ladies and gentlemen, and all those who have joined us online. I, Pranav Sankar, Joint Registrar List, Patna High Court, takes this opportunity to welcome you all to this one-day conference on the subject of understanding electronic evidence and cyber law, implications under the evidence law, Bharatiya Sakshya Adhiniyam, Digital Personal Data Protection Act, and IT Act 2000, and other relevant laws and landmark judgments. As our esteemed guests take their seat, let us remember that today's theme is both timely and also very vital. The legal landscape is demanding deeper insights and greater adaptability from us. This seminar brings together the experience and the expertise to illuminate these complex and emerging dimensions of the law. I now most humbly invite Honorable the Acting Chief Justice cum Patron-in-Chief, Bihar Judicial Academy, Honorable Mr. Justice Ashutosh Kumar, Honorable Mr. Justice Vipul M. Pancholi, Honorable Mr. Justice P.B. Bajantari, Honorable Mr. Justice K.N. Fanindra, Professor S.V. Joga Rao, and Dr. A. Nagratna to please take their seats on the dais. I also request our respected Advocate General Sir to please come on the dais. May I, with the permission of the chair, start the program, sir? Ladies and gentlemen, I'd request you all to please stand up in the honor of National Anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Before we delve into the complexities of the cyber law and evidence, we invoke wisdom and enlightenment through the ceremonial lighting of the lamp. So now, to formally begin this conference, may I humbly request the dignitaries on the dais to formally inaugurate the seminar by lighting of the lamp. Thank you, my lords. It is our privilege to felicitate the esteemed dignitaries. It is our privilege to felicitate the esteemed dignitaries whose presence has added immense value to today's program. As a token of our respect, may I now request Sri Purushottam Mishra, Director, Bihar Judicial Academy, to kindly present a Angavastra and a bouquet to my Lord, Honorable Mr. Justice Asutosh Kumar, Honorable the Acting Chief Justice cum Patron-in-Chief, Bihar Judicial Academy. Thank you, sir. I now humbly request Sri Vinay Shankar, Additional Director, Bihar Judicial Academy, to please kindly present an Angavastra and a bouquet to Honorable Mr. Justice Vipul M. Pancholi, Judge cum JD 1, Patna High Court. Thank you, Sri Vinay Shankar ji. I now request Ms. Divya Vasist, Deputy Director, Bihar Judicial Academy, to present an Angavastra and a bouquet to Honorable Mr. Justice P.B. Bhajantari, Judge cum JD 2, Patna High Court, cum Chairman, Bihar Judicial Academy. Thank you, Ms. Divya. I would now request Ms. Tanveer Kaur to present Angavastra and a bouquet to Honorable Mr. Justice K.N. Fanindra, former Judge, Karnataka High Court, and Up Lokayukt, State of Karnataka. Thank you, Tanveer. I'd now request Sri Kumud Ranjan to present Angavastra and a bouquet to Professor S.V. Joga Rao, Visiting Professor, National Law School of India, University. I'd now request Ms. Preeti Anand to present Angavastra and a bouquet to Dr. A. Nagratna, Associate Professor, National Law School of India, University. I now request Sri Vinay Shankar, Additional Director, Bihar Judicial Academy, to present Angavastra and bouquet to Learned Advocate General. Thank you, Vinay. We are fortunate to have amongst us Honorable Mr. Justice P.B. Bhajantari, Judge cum JD 2, Patna High Court, cum Chairman, Bihar Judicial Academy. Your Lordship's concern for the effective implementation of the three laws has been the guiding force behind this seminar. So may I now have the privilege of inviting your Lordship to deliver the welcome address.
Honorable the Acting Chief Justice Patna High Court come Patron Chief of Bihar Judicial Academy, Honorable Mr. Justice Vipul M. Pancholi, Judge come JAD1 Patna High Court, Honorable Members of the Board of Governors of Bihar Judicial Academy, Honorable Mr. Justice Mohit Kumar Shah, Honorable Mr. Justice Arvind Singh Chandal, Honorable Srimati Justice G. Anupam Chakravarti, Honorable Mr. Justice Alok Kumar Pandey, Honorable Mr. Justice Dr. Anshuman, all my sister and brother judges of Patna High Court, learned Advocate General State of Bihar Mr. Shahi, learned Registrar General Patna High Court, Director Bihar Judicial Academy, Member Secretary BSLA, resource persons Honorable Mr. Justice K.N. Panindra, former Judge High Court of Karnataka, Upalokayukta, State of Karnataka, Professor S.P. Jogarao, Visiting Professor, National Law School of India University, Bangalore, Dr. A. Nagaratna, Associate Professor of Law, National Law School of India University, Bangalore, officers of the registry, stakeholders, all the participants of this conference, including all the judicial officers of Bihar Judicial Service who are all connected through online mode, the SHOs of Cyber Police Station and also the team of IPRD. A very good morning to one and all. I am honored to address before this distinguished gathering of Principal District and Session Judge, SDJMs, Nodal Officers, Principal Magistrates of the Juvenile Justice Board, SHO of Cyber Police Station from all across the state of Bihar, officers of the Registry of Patna High Court, officers of the BSLSA, and all judicial officers from across the Bihar Judiciary. As a custodian of justice in an increasing digital world, the responsibility that rests upon our collective shoulders is immense and growing. The topic which we are to address today, understanding electronic evidence and cyber law implications under Indian Evidence Act, Bharatiya Sakshya, Adhiniyam, Digital Personal Data Protection Act, Information Technology Act, and other ancillary laws and landmark judgments is not just timely but also imperative. Now at the outset, I extend my heartfelt thanks to Honorable the Acting Chief Justice of Patna High Court for his unwavering support in facilitating this conference and see the light of the days, and also for sparing valuable time from his busy schedule for this conference. I must also thank the Honorable Acting Chief Justice of Patna High Court for bringing the necessary stakeholders together so that they can brainstorm on this contemporaneous relevant topic. And I am certain this conference will only enrich the academic discourse in BJA but in Bihar Judiciary too. The law, as we know, must evolve to meet the needs of the society it serves in an era where data has become more powerful than weapons, where crimes are often committed not in the physical world but in the digital domain. Our justice system must rise to the challenge of adapting and evolving. At the heart of this transformation lies electronic evidence, a powerful tool, but one that demands caution, credibility, and clarity. With the digitization of the communication, commerce, and criminality, the legal system must now increasingly grapple with the nature, admissibility, and reality of electronic evidence. Let us therefore examine, both in the principle and practice, how our statutory framework and judicial pronouncement guide us in navigating this complex terrain. To begin with, the Evidence Act of 1872, a colonial era law which has until recently been backbone of evidentiary procedures in India, recognizing the onset of the digital age, the Act amended through Information Technology Act 2000, introducing Section 65A and 65B, which specifically deal with electronic records. Section 65B establishes that for an electronic record to be admissible, it must be accompanied by certificate that authenticates its source, integrity, and generation process. This section was introduced to ensure that digital documents vulnerable to manipulation and can be admitted without compromising fairness. However, while well-intentioned, this provision posed practical challenges. Often, vital evidence was rejected merely due to the absence of this certificate, even if the content itself was unaltered and trustworthy. This led to critical judicial intervention, and those I will address shortly. Thereafter, in a significant overhaul of India's criminal law framework, the government introduced BSA 2023, replacing the Indian Evidence Act. This new law reflects a deeper understanding of the digital ecosystem we now live in. It expands the definition of documents and evidence to include electronic records, digital signatures, biometric data, and even blockchain and cloud-based data. Section 61 to 65 of the BSA deal comprehensively with admissibility, authentication, and verification of electronic evidence. Unlike its predecessor, it embraces modern digital realities, allowing digital logs, metadata, timestamps, and forensic tools to play a central role in validating evidence. By doing this, BSA seeks to bridge the gap between technology and truth, making digital evidence more reliable and easier to use in courts. While electronic evidence can bring perpetrators to justice, it can also infringe upon an individual's privacy. This is where the Digital Personal Data Protection, short DPDP Act 2023, plays a pivotal role. This act governs how personal data is collected, processed, and stored, emphasizing consent, purpose of limitation, storage of minimization, and the right to be forgotten. For law enforcement and legal proceedings, it creates a delicate balance, allowing access to data, but only under lawful and justifiable circumstances. When digital evidence involves personal data such as emails, short logs, biometric records, or surveillance footage, the DPDP Act ensures that such data is collected and used with legal safeguards. Unlawful data collection can now not only violate privacy rights but also jeopardize the admissibility of that evidence in court. Thus the DPD Act elevates the conversation beyond evidence and into the ethical and constitutional territory, preserving the rights of individuals even in the pursuit of justice. The Information Technology Act 2000 remains the bedrock of India's cyber law framework. It legally recognizes electronic records, digital contracts, and e-signatures, making them enforceable under the law. It also prescribes penalties and punishments for various cyber crimes such as hacking, identity theft, cyber stalking, and phishing. Crucial Section 79A of the Act authorizes the government to designate digital evidence experts and labs to certify the authenticity of digital records. With increasing cybercrime, digital footprints such as IP logs, server records, GPS data, and forensic images are now central to criminal investigations. The IT Act ensures that such data is legally valid and procedurally accountable when submitted in a court of law. I shall now briefly outline the few landmark judgments which has been guiding light for us in this era of digital evolution. In the state of NCT of Delhi versus Navjot Singh Sandhu Afzal Guru case 2005, the Honorable Supreme Court allowed secondary electronic evidence like printouts without a 65B certificate, sparking debate on procedural laxity. In Anwar PV versus PK Bashir 2014, Honorable Apex Court overruled the Afzal Guru case, holding that Section 65B certificate is mandatory for admissibility of electronic records. It was watershed moment for digital evidence law. However, in Shafi Mohammed versus State of Himachal Pradesh 2018, Honorable Supreme Court relaxed the requirement of Section 65B certificate, especially when party did not have access to the device. However, this judgment caused legal confusion. Therefore, in Arjun Pandit Rao Khotkar versus Kailash Kushan Rao 2020, a constitution bench reformed that the 65B certificate is mandatory and clarified that it can be produced at any stage of trial. The only exception is when the device is produced in court itself. Furthermore, in case Puttaswamy versus Union of India 2017, famously known as a right to privacy case, Honorable Court recognized privacy as a fundamental right under Article 21, and this decision has reshaped how surveillance, data access, digital evidence collection must be approached lawfully, proportionally, and with accountability. These rulings collectively balance the scales, ensuring that electronic evidence serves the cause of justice without compromising constitutional values. The use of electronic evidence and cyber law enforcement poses several critical challenges. Therefore, the courts must distinguish between admissibility of evidence and its reliability, ensuring that digital evidence is not just allowed but also trusted. The law must strike a balance between upholding privacy and enabling effective investigations. Judges, prosecutors, police, and lawyers need a specialized training in handling digital evidence and understanding forensic reports. Chain of custody, digital evidence must maintain integrity through proper collection, storage, and certification, ensuring that it is not tampered or altered. With the data often stored on foreign servers, international cooperation with the mutual legal assistance treaties has also become essential. To conclude, electronic evidence is no longer a supporting character. It is often star witness to in today's digital cases. From cyberbullying to financial fraud, from terrorism to corporate espionage, the truth is now buried in data, and our laws must be equipped to extract it safely and lawfully. The Indian Evidence Act and BSA, the DPDP Act and the IT Act together form comprehensive digital legal ecosystem. But the real challenge lies in implementation, awareness, technological competency. As we move ahead, let us ensure that the promise of technology does not become a peril to justice, but a path toward it. We must therefore strive to create a legal system where the digital truth is discoverable, admissible, and above all just. Thank you.
Thank you, Lordship, for surveying this evolution of electronic evidence, giving a brief history of the development of electronic evidence through detailed case laws. Thank you, Lordship, for perfectly setting the tone for today's program. It is our privilege and honor to have with us Honorable Mr. Justice Vipul M. Pancholi, Judge cum JED 1, Patna High Court. Your Lordship's keen attention on efficiency and details and lucid eloquence need no introduction. So may I now invite Your Lordship to address us all.
Honorable Mr. Justice Ashutosh Kumar, the Acting Chief Justice, Patna High Court. Honorable Mr. Justice P.B. Bajentri, JAD 2, Patna High Court and Chairperson of Bihar Judicial Academy. My sister and brother judges of Patna High Court. Esteemed resource persons, Justice K.N. Panindra, Dr. A. Nagaratna, Professor Jogarao, Learned Advocate General, Learned Registrar and the team of Registry, Learned Director, Bihar Judicial Academy, distinguished participants, ladies and gentlemen, good morning. It is an honor to stand before you today to speak on a subject that is shaping not only our legal landscape but also the very fabric of our society. Cyber law and electronic evidence, especially in the context of India's newly reformed criminal justice system, from financial transactions and education to governance, healthcare and personal communication, our lives are increasingly being conducted online. India today is home to over 97 crore internet users. Digital transactions, social media platforms, AI tools, and cloud computing are becoming part of our everyday life. According to the National Crime Records Bureau, cyber crime cases having jumped by more than 30% from 2020 to 2023, with over 65,000 cases registered in 2023 alone. And these are just the reported cases. चीफ जस्टिस साहब, आज न्यूज़पेपर में मैंने पढ़ा, यहाँ पटना आके मैं हिंदी न्यूज़पेपर पढ़ लेता हूँ. इन दैनिक भास्कर, टुडे मॉर्निंग दैनिक भास्कर न्यूज़पेपर, देयर इज़ अ रिपोर्ट. दुनिया में हर सेकंड ₹1.63 करोड़ की साइबर ठगी. देश में 6 साल में 42 गुना बढ़े केस. सो टुडे इज़ द न्यूज़पेपर रिपोर्ट. हर एक सेकंड में 1.63 करोड़ का ठगाई, साइबर ठगाई हो रहा है पूरे वर्ल्ड में, और हमारे देश में 6 साल में 42 गुना केस बढ़ गए हैं. सो दिस इज़ द situation today. Now we are witnessing an alarming rise in cyber stalking, online financial frauds, data breaches, phishing attacks, digital arrest, cyberbullying. Simultaneously, electronic evidence, be it CCTV footage, email trails, GPS data, or social media activity, has become central to investigating and prosecuting crimes of all kinds. The digital footprint is fast becoming the new fingerprint in the criminal justice system. Traditionally, our legal system was built around physical crimes, tangible evidence, and clearly defined jurisdictions. But the cyber world is fluid, borderless, and fast. This calls for a change in our approach in investigating and prosecuting crime. The worrying part is that while cyber criminals continue to evolve and adopt newer, more sophisticated technologies, our laws have struggled to keep pace. Many of our legal provisions were drafted in an era when computers, smartphones, cloud storage, and artificial intelligence were not even imagined. To tackle this issue, the Information Technology Act 2000 brought in some changes to accommodate electronic records. To overall legal system still faced significant challenges in recognizing, admitting, and verifying such evidence. The Bharatiya Sakshya Adhiniyam 2023 BSA brings a much needed overall in the treatment of electronic evidence, making it more aligned with the realities of our digital world. One of its most important changes is the expanded definition of document, which now clearly includes electronic and digital records, emails, cloud data, text, audio files, and more. This not only grants digital records equal footing with physical documents, but also strengthens their use in court. Section 61 of BSA makes it clear that no electronic or digital record can be denied admissibility just because it is in a digital format. In fact, such records are now given the same legal standing as traditional documents, provided they meet the conditions set out in Section 63. Beyond it, just admissibility, the BSA introduces a stronger emphasis on authentication and integrity. It supports the use of digital signatures, hash values, and detailed chain of custody documentation to verify the origin and preservation of electronic records. These reforms offer substantial benefits in how the legal system addresses the challenges of the digital age. First, it leads to greater efficiency in legal proceedings by reducing ambiguity and minimizing procedural delays over digital evidence. Second, it pushes for greater reliance on digital forensics, which means law enforcement legal professionals, and even the judiciary will need to strengthen their technical expertise. Conferences like this are more than just gatherings. They are vital platforms for addressing emerging challenges and sharing meaningful insights. A thoughtful peer group such as this becomes a powerful catalyst for self-growth, helping us reflect, re-evaluate long-held assumptions, and engage with diverse viewpoints. In doing so, we absorb best practices and stay aligned with the evolving needs of our time. This spirit of continuous learning keeps us the law dynamic and responsive and shields it from becoming outdated or rigid. We are also privileged to have with us resource persons and subject matter experts whose knowledge and experience will enrich these discussions and provide valuable perspectives for practical application. The three sessions being held today on various topics, various themes, cybercrime, electronic evidence, and data protection, will go a long way in deepening our collective understanding and shaping a stronger, more future-ready legal framework. I convey my best wishes to all the participants and stakeholders. Thank you. Jai Hind.
We are grateful for your Lordship's address, which has discussed a whole lot of issues, including the growing rise in the cyber crimes. This will be a truly enriching contribution to today's discourse. May I now have the privilege of inviting Sri P.K. Sahi, Learned Advocate General, Bihar, to kindly address this gathering. Sir.
Honorable the Acting Chief Justice Ashutosh Kumar, Honorable Justice V.M. Pancholi, Honorable Justice P.B. Bhajantri, Justice Faninder, Associate Professor Nagratna, Professor Joga Rao, Honorable Judges of the High Court, members from District Judiciary, police officials present here and other stakeholders. Very good morning to everybody. It's my privilege to be present amongst you on this important topic, which is engaging new dimensions of criminal activity. Honorable the Chief Justice yesterday, I would say, requested, but I take it as his direction to be present, and so I have the privilege of being part of today's conference. Justice Bhajantri has, in his prefatory address, flagged important issues with regard to electronic evidence and cybercrime. We all are aware that electronic communication and tools have obliterated international boundaries. Crime is being committed from any nook and corner of the world. It is posing grave challenges for the investigators and equally for the judiciary to tackle. Considering a new area of activity arising out of electronic tools and leading to cyber frauds, etc., some laws have been enacted. Justice Bhajantri and Justice Pancholi have referred to IT Act, Bharatiya Sakshya Adhiniyam, Data Protection Act, etc. However, we all have to strive to acquaint ourselves to the complexities which arise in collecting discovering and unearthing electronic evidence and produce it adequately safeguarded under the provisions of various statutes for its admissibility before court. Reference has been made to section 60 to 65 of Bharatiya Sakshya Adhiniyam. We have also to be conscious of limitations when we talk of right to privacy, as has been discussed elaborately in Puttuswamy case. So these are the issues which will keep us engaged in coming days. Needless to say that the cyber fraudsters are 2 steps ahead of the investigators. They deploy newer technologies, they employ experts that themselves are experts. So our investigators also have to accelerate their pace to match the speed with which cyber fraudsters are committing crime. Every day we read newspaper about digital arrest, cyber frauds, ATM frauds, banking frauds. Just now, Justice Pancholi referred to a news item that in every second 1.83 crore is being put at the altar of cyber fraudster. So I'm very happy that judiciary and especially Patna High Court is alive to the situation. We had several conferences in the past on broader topics. However, this conference focusing especially on electronic evidence and cyber fraud will go a long way in strengthening our system. Thank you very much.
Thank you, AG sir, for your kind address. Sir, we all know that you have been regularly part of such training program on all the 3 new recently enacted laws. And sir, again, you have pointed out all the important points and the relevant points. The August House, today we are all blessed and privileged to be graced by the kind presence of my Lord, Honorable Mr. Justice Ashutosh Kumar, Honorable the Acting Chief Justice of Patna High Court, Comptroller-in-Chief, Bihar Judicial Academy. Words fail as I seek to say something in honor of my Lord. Your Lordship's eloquence and oratory needs no introduction. So may I now humbly request our Honorable the Acting Chief Justice to please address us all.
A very good morning to all of you. Pranav has been rather generous in talking about me. That's don't take it as a correct statement. Nonetheless, let me see what I communicate to you. Justice Pancholi, Justice Bajantri, my esteemed colleagues, resource persons, the Learned Advocate General, the Registrar General, members of the Registry, officers of the Legal Services Authority, the Director of Judicial Academy and other officers of the Directorate, the participant judicial officers, police officers, ladies and gentlemen. When this conclave was thought of, I was only wondering whether it would sustain the interest of people, especially with respect to the wordings of the statutes. But the fact remains that we have been grappling with the situation where the crimes have become borderless and the personal data of all of you is on prowl of many. This is the reason why the checks on such crimes would be necessary. The reason why these crimes have increased and the scary statistics which was given by the speakers before, this is because of more information that we have gathered. Information is power. More information is more power. We have been really good at acquiring information, but not very good at acquiring wisdom. the human species, I must say, is very prone to acquiring information, acquiring power, which actually they don't know how to handle. This is the problem with lot of information to us. I am not going to tell you about the provisions of the statute. I am only trying to sensitize you why these laws have been enacted and why it is necessary for all of you to acquaint yourselves, because you would be the first responders, the police officers, the judicial officers. There would be a time when entire digital evidence would inundate your courtrooms, and you would hardly be left with, the evidence, what you say, oral and documentary. You will have all digital evidence with you to assess. But before that, you must know why wisdom is necessary for excluding certain information or handling the information which you have, which ultimately gives you the power to destroy, power to build, power to sustain. These are all powers of various dimensions which get accumulated in human beings only because of the surfeit of information. Let me tell you a short story, because I always believe that myths and stories have great power to bind people. And this is a lesson in history. So let me take you to the Greek mythology, where the sun god, the god of sun, Helios, had a child called Phaethon. Now Phaethon wanted to prove his divine origins, and therefore he demanded of his father that the solar chariot should be allowed to be driven by him. Helios was not happy. He said that, you see, human beings or even gods who are not particularly trained, they cannot ride the solar chariot. Please desist from it. But he insisted, and because the father was a loving father, he relented and he allowed him to drive the chariot. So one day he drove the chariot with the sun god on the seat, and he proudly traveled the sky. But because he was not very adept at riding, so he lost control. The sun god veered off the trajectory, and the result was that the entire vegetation was scorched. There was a fear that the earth would be burnt. And then everybody invoked Lord Zeus, the Lord of the universe. So he struck Phaethon with a thunderbolt, and he came down falling like a falling star. See, this is what happens if you don't know how to control the power. You end up in disastrous situations. Long after that, during Industrial Revolution, if you remember, when machines were replacing human beings for all the works, that was the time when the information with respect to automation was trickling down. And this was the same time when the same cautionary tale was given by one of the most talked about authors of his times, called Goethe, Wolfgang Goethe. Now he, those days, had given a story called Sorcerer's Apprentice. Sorcerer is a magician. Sorcerer's Apprentice became very popular because Walt Disney also animated it, and it's a great lesson for all of us, for the humanity of future. Now this is the story of a sorcerer who had an apprentice whom he was teaching the art of magic spells. And one day he had to go out, so he asked the apprentice that, please take care of my workshop and please fetch some water, bucketfuls of water, by the time I will come. So this man, this apprentice, he had only half-baked information from his master. He thought that let him make his work easy. So the half spells, magical spells that he had learned from his teacher, he cast that spell on a broom, jharu, and asked it to fetch the water. The broom, under the magical spell, started bringing water. This apprentice did not know how to stop the spell. So the broom kept on fetching water till water was in surfeit and it had almost inundated the workshop. In desperation, this apprentice put an axe over it, cut it into half, And see, there were 2 brooms now fetching water. And it was almost the time when the apprentice would have drowned himself. In the meantime, the sorcerer arrives. He would break this spell, magical spell, and then everybody was saved. So there is a lesson to the apprentice and to the humanity and to all of us. Please don't summon power which you have no idea to control. And only when you can control it, please summon power, please use your knowledge. Now, the telephone, I could not stay aloof from my telephone even for 5 minutes. I had to ask one of the ushers to bring my telephone there, which I had kept. This telephone now has become a constant companion. It holds for you the conversation, your memories, your photographs, all your personal, records, and therefore your footprints also, digital footprints, and which could be hard evidence. These, if it could be analyzed, it could unravel truth. And if mismanaged, it could distort the truth as well. Just think of a situation. Suppose inadvertently or accidentally, you get to watch some salacious content on your telephone. I think you would be civil enough to stop it. But then once you have seen it, not because of your choice, but because of inadvertence or chance, you would find that the algorithm of today is such that such salacious content, lascivious in intent, would keep on popping on your telephone. And that will leave a footprint in your own telephone, in the machine which you are carrying day in and day out. Your privacy has been breached. In case you fall in trouble, you're on the wrong side of the law. This footprint, digital footprint, could come against you, could come very handy against you. I mean, I'm not taking very overt examples of what can happen to you, but this is what digital footprints can lead to. Therefore, there was necessity of framing new laws, creating new regimes which would speak with encrypted chats, AI-generated contents, and cloud storage. So these are all over the blogosphere, and you have to learn how to ensure your privacy, and then how to ensure the authenticity of such materials if it is brought to you as piece of evidence. How would you take it as part of your evidence? How would you make it admissible in courts? How would you make it as a building block for coming to a right conclusion? And therefore these laws, and therefore the insistence for you to understand why these laws talk about strong rigors of certification, of experts verifying the contents, and many a times when it does not pass the muster, when it does not cross through such rigors, then it is to be rejected. Why? These are the reasons. Now, all of you know, the police officers and the judicial officers, digital evidence today is as good as document, provided you follow the caveats and you look for the rigors which has been provided in the Act for you to take it as an admissible piece of evidence. What I really usher to all of you is that you must improve your vocabulary of these words. Let it not sound like Latin to you when somebody says the hash value, when somebody talks about metadata, somebody would tell you the time spot, and things like that. You must be aware of these developments, and your vocabulary must include such technical concepts through which you will understand the working of these acts. This also lets you remain vigilant so far as your rights of privacy are concerned. Now, I'm sure these speakers, they're all very learned people, as I have come to know about them. They will talk about different cases, P.V. Bashir, Gorantyal, that Pandit Pandit's case and Navjot Sindhu. I am not going to talk about those cases. That falls in the domain of the subject matter, the topics which they are to deal with. Now, I'll tell you, most of you must have read this 2025 judgment of the Supreme Court by 3 judges, which was in spotlight very recently. Chandrabhan Sudan Sanap's case. I think all of you have read it because this is where the digital evidence was discussed, and the evidence which was put forth by the prosecution was rejected summarily by the Supreme Court. In this case, a young woman of 23 years of age was raped and murdered brutally, but way back in the year 2014. The trial continued. There was no evidence at all. This lady the deceased was a young, entrepreneur. She was in service and she was staying in YMCA in Mumbai, and she had gone to her village home, Machli Patna in Andhra Pradesh. She came back, she boarded the train. The father had left her at the train, had seen her off, and he was in constant touch with the daughter. The last of the conversation which the father had with the daughter, who died, was somewhere when the train was at Solapur station, and thereafter she was not to be heard of. Ultimately, she never reached Bombay. The father got worried, he came, lodged a case, nothing could happen. About 15 days thereafter, a very decomposed dead body, which was identified by the father because of a ring which she was wearing, that was found. There was no evidence. The local police tried their hands at investigating the case, but nothing happened. Ultimately, this Chandrabhan Sudan Sanap, I don't know what kind of name is this and what was his vocation in life, but he was arrested on suspicion because of some clips of video where he was seen running away, where he was seen vaguely running behind the woman, and there were video clips of his having received certain belongings of the deceased, a trolley bag, and somebody had confessed that he had seen. Now, this was the evidence when the trial court convicted and sentenced him to death. The High Court affirmed the sentence of death. Supreme Court said, no. This is not the way electronic evidence has to be dealt with. They first saw the clip, and the 3 judges, very celebrated judges of the Supreme Court today, all of them are sitting judges, Justice Gawai, Justice Manoj Mishra, and Justice Vishwanathan. They dealt with the entire law of digital evidence and said that if we accept this evidence, then injustice would occur. And it was all rejected. Of course, on other points, the law with respect to circumstantial evidence, the law with respect to medical jurisprudence, and somebody who had seen the appellant having committed the crime or seen with the deceased, his statement was recorded after a long time. All these points, but definitely one of the prime evidence of the prosecution was the digital evidence. There were about 200 exhibits which were produced in the court, including the forensic evidence, and there were a host of it. But the court was very clear in its import, read the entire evidence and found that this is misleading. It could distort the very trajectory of law, and therefore it was not accepted. Let me tell you another case from cross-border. I think I have some 5 minutes time, sir. I have 5 minutes time. I'll just sensitize them why it is important. Digital evidence can at times, cause a lot of problems. I think as popular as this case, or as infamous as this case would be the case of Bates versus Post Office, the professors would be knowing it. This is of 2019 in UK. Justice Fraser was good enough to decide how digital evidence, if not properly managed, could lead to disastrous results. Now, here was a case where the Post Office of England was being run by sub-postmasters who were not in direct employment of the government post office. They were individual persons, and they were business solution providers. They were employed privately by the post office. Now, sometimes during their employment, during their contract with the post office, the original post office, it rolled out a accounting format, accounting scheme, digital scheme, which was called Horizon. The sub-postmasters had to do it through the Horizon. And to to their great surprise and dismay, these sub-postmasters at one point of time found that there is unexplained shortfall in their accounts. But they couldn't check it because this was the functioning of the app which was provided to them, Horizon app. Now ultimately they were prosecuted because the accounts had big shortfall, and the central prosecution of England did not go for any prosecution of sub-postmasters. It was a private prosecution by the post office. And all of them lost their job, lost their contract. There were hundreds of them. Because there were many, as it always happens, the politicians pitched in. Newspapers were carrying news. And therefore the matter had gained a lot of publicity. Justice Fraser, when he looked at the matter, he said that let me see the functionality. Let me see the way in which these sub-postmasters were working at the bleeding edge, at the cutting edge of a new app. And it was found that it was the problem of the app and not of these sub-postmasters. And they were acquitted, and they were also held to be entitled for huge compensation. So this is one of the most sober reminders to all of you judges. You must know how to deal with digital evidence. Only because the app showed so, you could not have jumped to the conclusion that they had committed theft or there was unjust enrichment by juggling the accounts. So you have to be very careful, and therefore you have to ensure complete compliance of the rigors which have been provided in these acts. Digital, all these speakers, Brother Bajantri and Brother Pancholi, have talked about redefined crimes, hacking, phishing. Police officers know it better. Digital arrest. I am told that the wife of one of the ex-DGP of Bihar was under digital arrest while the husband was serving as DGP for about 4 hours. Can you believe that? Could you believe it? But it happens. Forget about the statistics. So you are the first responder. You have to get to grapple with this kind of a situation. You heard the number of the cyber crimes, the number staggering increase over a period of time. Are we really equipped to handle that deluge of evidence which will come in its train? No, we are not. We are not, and therefore this conclave. So please listen out to the speakers. This conclave, if you are serious about these intricacies of law and the new statutes, it will take you very deep. It will let you know how to authenticate a viral video on WhatsApp or Twitter, which is now X. How to trace a cryptocurrency payment used for ransom. Today, as Justice Pancholi read a Hindi newspaper, I too read an English newspaper, and the news was that one of the popular actors of Malayalam films in Kerala was arrested today. You know why? Because he could be traced with the digital payment to drug peddlers. And once he was arrested, a lady actor, a co-actor, she filed a case that he had misbehaved with her. Today, the name is Shine Tom Chaco. You would read it in newspapers. So this kind of digital deluge you have to handle. And social media, algorithms, the artificial intelligence, these are good things, developments, but they are dangerous monsters unless you know how to control them. I'll tell you just one story of Burma. It is what has happened. Look at the kind of misinformation which AI can generate. You would find it absolutely difficult to contend, to stop that projection. And therefore, one has to be very careful about the caveats that have to be obeyed before the evidence could be taken in. You know Myanmar, the western side of Myanmar. I would refer to it as Burma because it's easier to pronounce. The western side of Burma is inhabited by Muslims who are known as Rohingyas. Now, Rohingyas were prosecuted in that country by the government junta and the Buddhist majority. But then the Buddhist majority once thought that let it be told to people of Burma and the majority Buddhist that these Rohingyas, they commit terror. They are violent people. One of the extremist Buddhist monk called Virathu. He imagined that let me not do it, let AI do it. And the algorithm was made in such a way that the entire country received messages on WhatsApp about, the terrors, the fancied terror attacks by Rohingyas. A lot of misinformation. But there was another saint who tried to control it. His name was Bituddha. Now the Indian government also recognized the services rendered by him. And he gave refuge to approximately 800 Rohingyas from being murdered in his own monastery. There was a risk of his being murdered, and he had communicated to the Indian government as well, because many of them were trying to come over to this country. Now, what I'm trying to tell you is this, that there could be a host of misinformation. AI is very helpful for you to decide cases, but be very, very careful that AI, the automated algorithms with its own mind could spell disaster. And if, like an apprentice, you don't know how to control it, you would drown. You would drown in it. Digital Data Protection Act of 2023, Justice K.S. Puttaswamy case, these are brilliant expositions on the subject. After you're through with this conclave, please go through it. It will be right to be forgotten. These are important aspects. So, my friends, I tell you that we must, as a body, must acknowledge this shift. We must respond to the challenges. The challenges are like multi-headed hydra, and therefore we have to be very alert. And together, we must navigate this complex terrain, which is very difficult to navigate. So again, please hear out the speakers and share your takeaways with your colleagues, because I believe that individual competence is not enough and it does not mean much, but institutional capacity building does. So if you share your knowledge which you earn here with your colleagues, with others in your department, I think you would do a better job. Well, thank you for your attention.
Thank you, my lord. As usual, it was indeed a pleasure to listen to your lordship's great speech. We deeply appreciate my lord's thought-provoking observations, eloquent address, marked by depth and clarity, and with beautiful storytelling technique. My lord, it has added great value to the whole theme of this conference, and we'll carry it throughout the day. Lordship, with my lord's permission, can we just end this session? With my lord's permission, we end this inaugural session, but then we have a small announcement to make. Participants, we'll have a photography session in this auditorium room itself with all the honorable dignitaries. So all the respected participants are requested to please be seated in their respective seats. My lords will move down to the After we are complete with this photography session, I'll have a small announcement to make, so please be seated after this photography session. May I now request the August House to kindly rise in honor of very warm welcome to all in the first technical session of the seminar. We now begin the first session, which is focused on cybercrime and Indian substantive laws. This particular session will cover the Information Technology Act, the Bharatiya Nyaya Sanhita, and the special enactments like POXO Act. As digital infractions grow more sophisticated, so must our understanding of the statutory frameworks and how we address them, be it the Information Technology Act, the Bharatiya Nyaya Sanhita, or any other special legislation which covers them. This session will help us in exploring the traditional legal principles, how they are being tested and reshaped in the face of cyber threat and the evolving criminal behavior. This particular session will be chaired by Honorable Justice Srimati Soni Srivastava, Judge, Patna High Court. Your Lordship is also known for her oratory skills and has been recently elevated to the bench. Your Lordship has had illustrious practice on criminal side before joining the bench. The topic will be dealt in detail by our distinguished speaker, Dr. A. Nagratna, Associate Professor, National Law School of India, University, Bangalore. We are delighted to welcome Professor Nagratna, an esteemed faculty member at the National Law School of India, University, Bangalore, with specialization in criminal law, cyber law, and commercial law. She is a rank holder and a gold medalist from Bangalore University, and she began her teaching career in the year 2001 and joined National Law School in 2006. Professor Nagratna is a prolific researcher and has contributed significantly to areas such as medical law, IPR, and consumer rights. She serves on expert panel and review committees for various academic and professional bodies. May I now invite the Honorable Chairperson and the Speaker on the dais to please enlighten us on this topic. I now humbly request Ms. Dabya Vasist, Deputy Director, Bihar Judicial Academy, to please felicitate Honorable Justice Srimati Soni Srivastava. I now request Ms. Tanveer Kaur, Administrative Officer, Bihar Judicial Academy, to please felicitate Dr. A. Nagratna. I now hand over the dais to my Lordship.
Honorable the Acting Chief Justice, Patna High Court, Mr. Justice Ashutosh Kumar, as also the Patron-in-Chief of the Bihar Judicial Academy, Honorable Mr. Justice Vipul M. Pancholi, JAD 1, Patna High Court, Honorable Mr. Justice P.B. Bajantri, Judge cum JD 2, Patna High Court, as also the Chairman of the Bihar Judicial Academy, Shri Purushottam Mishra, Director, Bihar Judicial Academy, Shri Binay Shankar, Additional Director, Bihar Judicial Academy, the Registrar General of Patna High Court, and the members of the registry, the police officials who are all present here, respected dignitaries, esteemed panelists, distinguished guests, ladies and gentlemen, a very good morning to all of you. It is a matter of great honor and responsibility to be before this august gathering to open today's deliberations on cyber law, a field whose relevance deepens with every passing day and whose contours demand constant reflection. We live in an era where almost every aspect of our personal and professional lives is digitized. From banking to education, healthcare to communication, governance to commerce, everything is being redefined by technology. Cyber law, though once considered a niche area, has now assumed central importance. With the transformation comes a parallel rise in digital vulnerabilities. Cyber crimes such as identity theft, data breaches, financial fraud, online harassment, and cyber terrorism are not just IT subjects, but are legal, ethical, and societal challenges. And that brings us to today's focus in the present session, which is the session 1, in which we are concentrating on cyber crimes and the Indian substantive laws, with special reference to Information and Technology Act, Bharatiya Nyaya Sanhita, and other special enactments, including the POCSO Act and the other acts. The statistics would show that the number of cybercrime incidents reported in the country doubled in the last 5 years, with a steadily rising trend. In the case of cybercrimes against children, the reported incidents have increased 15 times in the last 5 years. The trend of cybercrimes cases under Section 14 and 15 of the POCSO Act in the last 5 years shows that registration of such cases are on a rise. The number of cases registered under Section 67B of the IT Act has been increasing in the last 5 years, which is cybercrime against children. With the outbreak of the pandemic, the crimes committed online for sexual exploitation have increased, especially crimes against children for their gullible and trusting nature. It is thus the need of the hour to start working on reducing and eventually putting an end on cybercrimes. Sections 294, 77, 303, 78, 317, 318, 336, and 356 of the BNS, dealing with several online offenses like electronic publication and transmission of obscene material, voyeurism, cyber-stalking, creation of bogus websites, and cyber frauds, bear penal consequences. BNS thus plays a complementary role in providing punishments for specific cyber offenses alongside the IT Act, and then offers a legal framework for penalizing the offenders. No doubt it is true that the recent legislative reforms mark a significant milestone in modernizing the nation's criminal justice system by introducing provisions tailored to the digital age. These new laws aim to deter the proliferation of cybercrimes that have become increasingly prevalent. Crimes like child pornography, cyberbullying, cyberstalking, cyber-grooming, online job fraud, online sextortion, phishing, and so on and so forth. Cyber law is thus of particular importance in countries like India, where the internet is used widely. In order to protect both individuals and organizations against cybercrime, the laws were enacted. These laws, however, need a constant upgradation and refinement to keep pace with the increasing reliance of humans on technology. There is a need for legislators to take extra precautions to keep ahead of the imposters. However, ultimately, it is up to the users to participate in the fight against cybercrime. The only way for the growth of online safety and resilience to take place is through the consideration of the actions of these stakeholders, ensuring they stay within the confines of the law of cyberspace. I would not take much time because we have a resource person with us, and I think she has already been introduced. She is Dr. A. Nagarathna, Associate Professor of Law at National Law School, Bangalore. And I would now invite our speaker to educate and enlighten us on the key themes so that we get a broader vision of the diverse perspectives of the enactments and laws to curb cybercrimes and thus enrich our understanding on the subject. Over to you, Dr. A. Nagarathna.
Thank you, ma'am. Honorable Mr. Justice, sir, Justice Ashutosh Kumar, sir, Honorable Mr. Justice Vipul Pancholi, sir, Honorable Justice Bhajantri, sir, other Honorable Judges from the High Court, respected ma'am, respected resource persons, esteemed guests, esteemed delegates. I think what I'm going to talk about is more a theoretical and academic, inputs. And in fact, you are the experts because you apply the law in the field. So mine only comes from my research and teaching from the class. Thanks for having me here, sir. It's a honor to be here amidst such wonderful gathering, and especially after morning's talk, I feel it's going to be very tough for us, the resource persons, especially for me, because sir's talk was equal to the entire day's technical session. So I'll try to address on the substantive provisions of law.
Ma'am, you can be seated.
No,
if you're comfortable.
I'm comfortable standing. As a teacher, I'm used to stand. Yeah. So this session will be on substantive law, which is a very, very wider, in fact, topic, because what we today have is an extremely comprehensive law. Good or bad, effective or not, is another debatable issue. But we have a lot of provisions of the law which can be used to regulate various forms of cybercrimes. As we've been discussing from morning, there are changed versions of cybercrimes coming up, increased numbers of cybercrimes, which requires regulation, and constantly changing law is important, but we all know it's not practically possible. So when that's not possible, so what is the remedy? So the best remedy is to apply the existing provisions with a meaningful judicial extension and interpretation. So that's what I'm trying to address through these provisions. As we all know, the crimes are increasing, especially cyber crimes. And one unique thing that we notice when it comes to cybercrime is we just don't see the increase in the number. We also see that it is changing its form, and there are multiplications of changed versions of cybercrime. What we didn't hear a few years back has become reality today, like deep fakes or digital arrests, etc. Of course, the debate can be like, are these new crimes or are these just new versions of already known crimes? But otherwise, what we see today when it comes to cybercrime is an increase in the number of crimes getting reported as well as not reported. So I'll try to cover provisions from the most importantly Information Technology Act of 2000, and to the extent possible from the Bharatiya Nyaya Sanhita, and briefly from POCSO. So of course, there are other laws also which are important, which can be used to regulate cybercrimes. Paucity of time, I may not be able to cover the provisions, but my whole input would be that existing legal provisions can be extended to regulate cybercrimes. For example, the Immoral Traffic Prevention Act, or Indecent Representation of Women's Act, or POSH Act, that is Protection of Women from Sexual Harassment at Workplace. All of these can also be used to regulate cybercrimes in the given scenario. Now, coming to the first one, the Information Technology Act. Though the Act came in the year 2000, as we all know, it initially did not focus on regulating cybercrimes. IT Act of 2000 came up mainly because we wanted to promote and facilitate e-commerce and e-governance, because the UN General Assembly mandated every member state to the UN to have a law which facilitates e-commerce and e-governance. So therefore, we had a law which was focusing more on facilitating e-commerce and e-governance and less on regulating cybercrimes. Also because people were thinking that cybercrimes can only be a myth. It can't be a reality. Until 2008, when we became the victim of the unfortunate terror attack in Mumbai. So that's when we realized how this technology can be misused even to commit terrorism. Now in that case, Kasab and other terrorists were using satellite phones, SIM cards, etc. So that's when we had to make immediate changes to the existing law framework, and we added lot of provisions to the Information Technology Act with the objective of regulating cyber crimes. So therefore, this was the reason why we had to shift our focus from just merely facilitating e-commerce and e-governance to regulating cyber crimes. So today what we have are very, very wider laws. So one thing we notice when it comes to cyber crime is the name with which cyber crimes are known in the generally known are not the terms used in the IT Act. So it's essential that we match the two. For example, hacking is not a term used in IT Act, or phishing is not a term we use in IT Act, but the existing law should be extended to these scenarios. Chapter 11 of the IT Act deals with cyber crimes. The first section is section 65, and if we see the provision, it says if anyone alters, deletes, destroys any computer source code, he can be booked under this provision. But as of now, there is a problem in the provision. Is the reason why I often feel that this is not a suitable provision if you see from prosecution perspective. Because it says this section applies if the source code I have altered, deleted or destroyed is that which is required to be kept for the time being, and required to be kept as per the law for the time being in force. Now, which is this law is not clear. So which means a computer source code of my laptop or your laptop or my mobile phone or your mobile phone, if is altered, if you book a case under this section, my defense will be that that source code is not anywhere mentioned as the one that needs to be required or kept as per the law which is applicable for the time being in force. So this makes one of the ingredient of the offense usually absent in a case. So not many judgments under the provision, though there are few judgments by the trial courts, but I'm sure if it is challenged in the High Courts or Supreme Court, it might be very difficult to sustain the conviction. So then what is the alternative? Of course, we have other section which better suits, say, protecting computer source code, especially since today we have police officers here. I think identifying relevant section is very, very important. When it comes to cyber crimes in India, what we also see is that often cases are booked under irrelevant sections or sections which actually doesn't apply to a case scenario, and that becomes a very easy ground to even discharge the accused or acquit the accused. So therefore, identifying relevant section is very, very crucial. Then we have section 66, which is often used provision when it comes to cyber crimes, because this covers various forms of cyber crimes. But the section is simple. It says any offense covered under section 43, if is committed dishonestly or fraudulently, it becomes a crime. So 43 actually deals with civil offenses, and the same civil offense, if I have committed with mens rea in form of fraudulently or dishonestly, it becomes a crime under 66. So let's see what falls under 43. Firstly, 43 small a covers hacking, because it says if any person without the permission or authorization by the owner of a computer accesses that computer, it's an offense. So I just access your mobile phone, your laptop without your permission is an offense under small a of 43. Now another very important thing here is when we amended IT Act in the year 2008, we gave a very, very wide definition to the terms computer, computer system, computer network, computer resource. Now these definitions, if we see, they're so wide that it can cover any new versions of technology. You call it as AI, you call it as any new versions of technology like driverless car, etc., or any devices which functions on software programs like ATM machines or my smartphone or smart watches or smart television. All of this today falls under the definition of computer. Now when I'm accessing that computer, including communication device, a mobile phone, A applies. Now, secondly, what we also notice is in all the sections, especially 43 we see, we're criminalizing offenses in stepwise. I hack, one step is over and an offense is committed. I hack and steal data, another offense is made out. So stage-wise we've criminalized. Now, B is about a data stealing. Anyone who steals data from a computer, including if we see, even from a removable storage medium, which is like pen drive, floppies, SIM cards, memory cards, etc. And I don't have to steal entire data. If you have a 10-page document, just steal 1-page document, the offense can be made out because it says whoever extracting would mean even part of the data is stolen. So therefore, it is wrong to say that India doesn't have a data protection law. Even before DPDP Act came, we had these provisions. So, and then if we see B, it's covering all data, personal data, non-personal data, critical data, whatever you name it as, it all comes under B. Then we have clause C, which talks about malware attack. Again, irrespective of the name of the malware, technically you call it as WannaCry, you call it as any form of malware it is, virus it is, worm it is, it falls under C because introducing any malware or computer contaminant falls under C. D is where I'm damaging a computer or a computer system or a computer network or a data. So I physically damage a laptop, D applies. I don't damage the laptop, but I damage the file in the laptop. I just delete a file. So D applies. So deleting or damaging computer comes under D. E is about causing disruption to computer. I don't break your computer, but I cause disruption. Maybe I send a malware. Because of that, your computer is not able to work. Or causing disruption is a wider term. Let's assume I'm yet to charge my laptop, and when it is getting charged, I'm doing imaging also. Like in the crime scene, I'm the IO, I'm collecting evidence from doing the imaging. So in the meantime, I remove the accused removes the electricity supply to the system. It doesn't work. It stops. Maybe it didn't have battery backup. So those kind of scenarios can also fall under E. D is I do not allow you to use your own computer, denying your access to your computer. I can do it through, again, malwares, through encryption or through ransomware attacks, or I can just do it just by putting a password on your laptop. Right? So not letting you use your laptop falls under F. Then G covers providing help to another person to hack. I don't hack, but I help another person to hack. H applies in a case, this is again interesting because it just says it applies in a case where one is getting the services, the other is getting the bill for it. For example, I am misusing someone's ATM card or credit card. So while I am shopping, he is getting the bill. Or this can also apply to internet time theft case. I am using your internet time and you're getting billed for it. So this also can be covered under H. I includes offenses of, say, destroying, deleting, altering any information that is there in a computer. Destroying, altering, deleting, including any offenses where the information that is there in the computer loses its value. For example, I steal your password or I just see your password. The moment I see your password, so the password loses its validity. So even that can fall under I. J, I think, should replace 65 for the time being because 65, as I said, has a very limited application, and as of now I feel it's a redundant provision because unless computer source code is the one which is required to be kept or maintained as per the law applicable for the time being in force, you can't use 65. So the place of that, J is a better option. J of 43 covers offenses related to computer source code. Now all of these are civil offenses under 43, and compensation can be claimed by filing a civil complaint before the adjudicating authority under the IT Act, who is the highest rank officer, who is the chief secretary to IT department. So the same becomes a criminal offense under section 66. Then we had 66A, which is now removed, unfortunately, despite it being struck down by the Supreme Court. There are still a lot of FIRs getting filed under this section. There are trials continuing under this section, which is not correct because few years back Supreme Court has said that such trials are wrong. You should not be conducting such investigations or trial because section doesn't anymore apply because it was struck down by the Supreme Court in Shreya Singhal versus Union of India because court says that this was against Article 19, Clause 1, Clause A. However, very recently when we were passing all these new laws, Bharatiya Nyaya Sanhita, etc., we also passed another law called Jan Vishwas Act. So this was passed in the year 2023 November. Now Jan Vishwas Act has clearly said that this section no more applies. So it's now also been removed from the Bare Acts. Now, however, what if I still post something abusive, something that can create communal violence, something which is hateful, or something which has false information? So because 66A doesn't apply, now we should find alternative provisions to regulate these online abusive contents. And that's the reason why we can take the help of BSA's some of the provisions. Well, some of these provisions were already there in the IPC. Some have been recently added, some have been amended. Most importantly, BSA has added electronic term in various sections, widening the scope of those terms. Now, some of the sections which can replace 66A in a genuine case are these. Section 197 1D covers offense of, say, sharing false information of such a nature that it can affect sovereignty, security, or integrity of the country, or sharing any false information again through electronic means, that is through online platform, etc., which again has abusive contents. Especially the last one is more important. Anything that can incite offense of, say, bringing in, say, affecting the communal harmony or harmony between different classes, community, etc., can be covered under this section. Then we have sections like 353s of BNS again, which however says that if at all whatever I am reporting is a true statement and is being published by me in good faith, I come under the exemption from criminal liability. Defamation provision today includes, of course, as we all know, cyber defamation also. The section hasn't undergone any change, except that for this today, the court can impose community service. So otherwise, the defining provisions, exceptions, explanations are all the same. Then, though the ministry said we've removed sedition provision, there are criticism saying that this provision has been replaced. So again, it's a debatable issue, but which is a provision which is said to be replacing sedition provision? It's 152 of BNS, which says if I publish anything, including through electronic mode, and if that brings in separation between groups, if it brings in discrimination between groups, so it can be covered under 152. So therefore, in the place of 66, we have a lot of provisions, including the ones I just mentioned. Apart from this, IT Act again covers offences like, say, receiving any stolen computers and communication devices. Especially today, a lot of youngsters keep buying online electronic devices, especially platforms like OLX, etc., is where we go buy laptop, mobile phone. If it turns out to be a stolen laptop, stolen computer, stolen communication device like a mobile phone, one can be booked under section 66B. So this is just for receiving or retaining stolen computers, stolen communication device, but the section is wider than this. It says even receiving a stolen computer resource. Now what is a computer resource? If we see the definition, it even includes software programs. So which means if I today buy a pirated software program, like let's assume you're the Netflix owner, you have the license, but I'm illegally using it. So I can be booked under 66B because this includes even pirated software programs. 66C, I'm sure again is a very popular provision because it's often used in the context of online financial frauds, phishing, wishing, etc. This is where the accused is stealing the identity of another person. So for example, creating a fake web page, which is exactly like the web page of a bank, insurance company, etc., or creating fake social media profiles can all be covered under 66C. Usually in digital arrest, this can be one of the relevant provision because here is where someone is posing as somebody else using online platform, like I'm wearing the uniform of a police officer, etc., and making the victim believe I am from the police, excise, customs, etc. So this can be one of the relevant section. Now I am cheating, stealing another person's identity, only 66C applies. I steal his identity and cheat another person, 66D applies. That is, I make A believe I am B and A sends money to me, etc. So then 66D applies. If I just create a fake profile, 66C, using that fake profile, I cheat people, take money, etc., it is 66D. So therefore, again, you can see 66C and D are like, stage related crimes. So while one is usually like an attempt, The other is, a commission of cheating. So that's 66C and D. Again, whenever we apply 66C and D, relevant provisions related to cheating from IPC or now the BNS can also apply. Then we have 66E. Now this is where we have seen some wrong FIRs being filed because the title says violation of privacy. There are some FIRs filed in a case where someone has stolen a personal information. But if we see the content of the section, this has nothing to do with stealing personal data. It's not about stealing personal information. This is more about what we call as breach of bodily privacy. This usually applies in a case what is usually called as voyeurism, that is taking pictures or capturing or transmitting pictures or making video recordings of a person's private parts of his body, basically having a hidden camera in a changing room, washroom, etc. are the scenarios which can fall under this section. So then again there is an interesting aspect here. Along with 66, even BNS applies. Now we have 354, we had 354C of IPC, which also covered voyeurism, but since 354C was added after the unfortunate Nirbhaya incident, this was a more women-centric law. So in this case, the accused always had to be a man and victim had to be a woman. So this was the IPC provision. Now the BNS replaces this. Though BNS claims to be making gender-neutral law, we still have some limitation here. Here now it says accused can be anyone. It says whoever. So therefore you can include man or even a woman or third gender, but victim should still be a woman. So therefore today for voyeurism, it still is a gender-specific provision under BNS. So therefore in a case where the victim is a man, I think 66C is a better, E is a better provision from the IT Act. So therefore, today voyeurism can fall both under BNS as well as IT Act. IT Act gender neutral and BNS is still gender specific when it comes to the victim. Then we have cyber pornography and obscenity related provisions. Publishing or transmitting obscene materials, including say text contents, video contents, audio contents, etc., falls under 67 and 67A. I'm sure we are all aware of the recent incident of a person making certain statements on a podcast, right? So that has raised a question about freedom of speech and expression on one hand, as well as on the other hand about need of regulating such content. So those kind of contents can fall under 67 or 67A, depending upon the nature of subject matter. Now 67 uses the words which were used by the Supreme Court in Ranjit Udeshi case. It says any content which can affect, if we see the words used in the provision, it says any content which affects the prurient interest of the person who comes across that content, or which depraves his or corrupts his mind, etc. So it's quite a wider provision because the words used are nothing but what was also applied in a case called Hicklin. So it's Hicklin's test which is retained by the provision. Apart from this, we have 67B, which ma'am was mentioning in the context of online protection of children. Now 67B covers child pornography, but the section is wider. While 67 and 67A, which are about adult pornography, only criminalizes publication or transmission. It doesn't criminalize possession, but 67B covers even possessing, collecting, browsing, seeking, even at the preparation stage. I'm just searching for child porn material, I can be booked under 67B. So very, very wider, even creation or even online grooming of a child falls under 67B. Now, usually in these kind of cases, POCSO also will be relevant, and POCSO, which was enacted in the year 2012 and came into effect from 2013, and later underwent changes in 2018, gives definition to child pornography, which wasn't given under IT Act. It was only saying whoever creates, publishes, etc. But what exactly is child pornography wasn't defined until recently. So 2DA defines child pornography very widely. Most interestingly, it says that even computer-generated contents can be covered under the definition of child pornography. A real child might not be there. I'm just creating digital contents, maybe by using deep fakes, etc., AI, etc. So even that can fall under the definition of child pornography. Section is very, very wider. This also covers offences of online online sexual harassment of child. So, and we see the definition of sexual harassment of child, it's very wide. Even making a child watch child porn content is an offense under section 11. Then we have section 13, which covers offenses of using a child to create child porn contents. When it comes to possession, we have multiple provisions depending upon why I'm possessing, how long I'm possessing. Some sections might become relevant. So this is section 15, which says storing pornographic material and not deleting it or destroying it is an offense under subsection 1. Then unless my intention of storing it was so that I could give it as an evidence before the court or before an inquiry committee, etc. Or storing any child pornographic material with an intention of, say, for the commercial purpose, we have another section. So what we see is under this section, you have gradation of offences. Depending upon the mens rea, punishment can increase. Also, possessing pornographic material for the purpose of transmitting it or sharing it with another falls under subsection 2. So if I just have forget and I don't delete 1, I have, and it's for, say, transition, publication 2, I have, and it is for commercial purpose, it's subsection 3. And very recently, Supreme Court has elaborately discussed about each of these subsections in a case where even the justice was saying that the right term in the place of child pornography is CSEAM, child sexually exploitative and abusive material. So the justice is suggesting that we should stop using the term child pornography because many times this term fails to take care of various other concerns a child faces when the child becomes the victim of child pornography. Then we have provisions relating to cyber terrorism, quite a wide provision, but any cyber crime, especially hacking, sending a malware or denying access to a person who is authorized to access a computer. So all of these normal cybercrime becomes cyber terrorism if it is committed with the intention of, say, doing anything that can affect security, sovereignty of the country, or to create terror in the minds of the people, or whatever I'm doing can affect the supply of essential services. For example, attacking a power grid or attacking a computer in AIMS, kind of a hospital. Those scenarios we've seen. So they can fall under this section. Then we have subsection 2 of the same section, which says even accessing any information which was supposed to be confidential. I access it without authorization. So I can be booked under this section. So here we have some clauses which are little debatable on as to whether they are valid or not. Tomorrow if someone challenges constitutional validity of this section, I feel this can also see the fate of 66A because it's so widely worded. It says even accessing any information which affects public order, that is fine. Accessing any information which if disclosed affects security, sovereignty, integrity, that is also fine. But which affects morality or which affects decency, I don't understand why this had to be brought under cyber terrorism. Maybe they're talking about case where there's been incidences of members of the armed force, who have been subjected to sextortion, who also been cases of say state espionage by using hackers, etc. So or cases of honey trapping. Maybe that's what they want to cover, but it's still little a vague provision. Or any offence which can lead to contempt of court or can become defamation or can incite offences. I think these parts are little problematic. So unless again judiciary gets a case to give an interpretation or opinion, I think this section as of now I feel is not rightly worded except subsection 1. So this is 66F. If I am hacking any protected computer, I can be booked under 70. What is protected computer? Any government, state or central, can notify any computer which is used for, again, supplying essential services to life. Again, electricity supply or, any computer used to, say, regulate train timetable, etc. So those kind of systems, including power grids, etc., if are hacked, so the offense under 70 can be made out. So hacking 66 or 43, hacking a protected computer 70 applies, provided that computer is notified. Not many computers are notified as protected computers in our country, except few by, say, Delhi government, Goa government, Maharashtra, and some by the armed forces, RBI, etc. So unless we declare a system as a protected system, this section cannot be used for charging. Apart from these provisions, we have parallel provisions from BNS, which are recently inserted into our Indian substantive criminal law, which can also be used to regulate terrorism, including cyber terrorism. Though this provision doesn't use the word cyber terrorism, it says committing terror by using any other means of whatsoever nature. It says any other means of whatsoever nature. So therefore, if I commit terrorism by using electronic means, this section can apply. And we see it's a very, very wide section. And then whoever just recruits somebody to terrorist organization, today it's happening on social media platform. I can recruit terrorists through online platform, or collecting money for terrorism activities. This is also happening through online platform. So a lot of things happening on the online platform today can be covered under section 113 of the BNS. Similarly, we have again, it's a wider section, so just conspiring, attempting, becoming a member, etc. It's all covered under different subsections. So since I have positive time, so I'm just running through, unless there are questions at the end. Now, why was this section added, and what would be the impact of adding this section into BNS? Now, earlier Terrorism Act would only come under UAPA Act, or sometimes maybe state-specific State Organized Crimes Act. So the regular police were not getting into investigation of these offences, but today, because it's been inserted into BNS, regular police may also be required to investigate these cases. So when the question of, say, applying either UAPA or BNS comes, the Superintendent of Police can take a call and can decide to apply either of the two. So therefore, there will be some occasions when regular police will be required to investigate cyber terrorism or terrorism. Then we have offences, cyber crimes committed in company, any cyber crime, say child pornography, hacking, data stealing, data destruction, etc. if is committed in a company. Again, today, there is also an increase in the number of corporate espionage, corporates recruiting hackers to steal data of the rival company. So those kind of offences, if are committed in the company as well as the officers running the affairs of the company, like manager, director, etc., can be booked under section 85. Abetment to commit any cyber crime falls under 84B. Like IPC, this also includes 3 forms of abetment: abetment by incitement, abetment by aiding, and abetment by conspiracy. And that's what the statutory explanation says. So I just abet another person to hack a system, to steal a data, I can be booked under this section. Alternatively or additionally, we have BNS also, which applies for this kind of inchoate preliminary offense, that is abetment. In fact, IPC itself had this provision, which is very rarely used. If I am committing an offense of abetment by way of, say, hiding or concealing information, somebody has committed a crime and I'm hiding it, I'm concealing it, I can be booked under this section. If you see, interestingly, this section even covers hiding such information by technical measures like encryption. So what is encryption? In simple term, it's nothing but just putting a password. So there is an evidence in a laptop. I just put a password to that file, and you're not able to decrypt it. You can't extract it. So I can be booked for just hiding this information, or any other ways through which I'm hiding this information. For example, today let's assume there is a file with some evidence on it. It's a Word document. I just change the color of the font from black to white. So IO, unless of course he's careful, he's trained, etc., might think it's a blank page, but maybe there is evidence in it. Even doing these small tricks of hiding evidence, especially in the context of digital evidence, etc., this section can apply, because this is wide enough to include using encryption or information hiding tool. Today, in fact, we also see increase in the number of offences where steganography is used. What is steganography? Steganography is a technical method through which I'm hiding one evidence behind the other, one file behind the other. For example, let's assume I send an email with Word document. So the IO thinks it's only Word document, there's nothing behind it, right? But that Word document, maybe behind that I've hidden a video document, or maybe I've hidden an audio document. That video or audio may have evidence. So just the art of or skill of hiding one document behind the other is usually done through steganography. So that can also be covered under section 58 of BNS. Then attempt to commit any cyber crime, again under IT Act, is covered under 84C. So I'm just attempting, this section applies. Then there are some provisions from the BNS which can be used to regulate cyber crimes against women. Most importantly, voyeurism we've already discussed. Then sexual harassment, this also, like POCSO, includes offences of online sexual harassment of a woman here. So even making a woman watch pornographic content forcefully can fall under this category. category of the offense, sexual harassment. Similarly, stalking, that is continuously sending unwanted messages or watching the internet usage of a woman or using a GPS device and tracking her movement, etc. So both physical and cyber stalking is covered under this section. This continues to remain gender specific. Accused has to be a man, victim should be a woman. So this is stalking. Then we have words or gestures or acts intended to insult modesty of women. This can again include online acts, online words, etc. Again, similar to this, we have POSH Act. If it is done in the workplace, I send some unwanted message, etc., with sexual intent or which has sexually colored remarks, etc., this section can apply. So as I already mentioned, voyeurism can also be brought under this category. When it comes to other forms of cybercrimes, so some forms of cybercrimes which are repeatedly done, if the accused is repeatedly involved in committing cybercrimes, organized crime related provision can become relevant. Until BNS was enacted, organized crimes was more regulated through state-specific laws, like we have Karnataka Organized Crimes Act, Maharashtra Organized Crimes Act, etc. But today, for the first time, our substantive criminal law, BNS, covers organized crime. And if we see the definition of organized crime, very, very wider, it says any continuing unlawful activity, including cyber crimes. So if I'm continuously doing it, or trafficking of person, this also can happen today with the help of online devices, or drugs. Again, I can sell these through online platforms, or selling or buying, etc., illicit goods, including weapons. So all of these sins can happen through online platform. Some forms of cybercrimes can be regulated through this provision. If it is done by a person who is member of a group or by a group of criminals, etc., and who fall under the definition of organized crime syndicate, this section applies. So therefore, organized crime can apply especially for habitual offenders who are repeatedly committing these kind of cyber crimes. Then subsections gives the definition of what is an organized crime syndicate, what is unlawful activity. It also gives the definition of economic offense. So anyone who is continuously involved in committing economic offense can also be booked under organized crime. And if we further see the definition of economic offense, this even includes mass marketing fraud, which can happen through online platform. This also includes, say, other ways of committing defraud on people. Again, this can happen through online platform. So therefore, there are a lot of clauses which can be extended to online scenario. And we have, again, like terrorism, different subsections under which being a member of the group, he can be punished. Committing the offense, he can be punished. Collecting the proceeds of the crime, he can be punished. So there are different subsections. BNS also widens our cybercrime regulatory framework by way of giving wider definition to certain terms. For example, I'm just giving some examples. Document now gets a wider definition to even include electronic and digital records. Earlier, of course, when we came up with IT Act, parallelly IPC was also amended to include e-records, but today we use the word specifically digital records. Most importantly, I think this is an interesting change. We've now amended the definition of movable property. Earlier, movable property only included corporeal properties, tangible property like cash, jewelry, etc. But today we include under this property of any kind which are movable. So today theft of a movable property should even include theft of an intangible property. So today therefore intangible property includes data, IPR, etc. So today IPR theft, data theft, it can also be covered under the definition of theft. So earlier theft only covered corporeal property, but now theft will include even theft of incorporeal property. So therefore either I can choose IT Act or I can choose BNS for data theft. Similarly for stealing any contents on the online platform, including digital assets, including IPRs. Mobile snatching again is a very commonly committed offense often. So we didn't have a provision earlier specifically to deal with this kind of snatching kind of a scenario. We could only use extortion or robbery. But today 304, which is recently inserted through BNS, includes snatching of any devices, including mobile devices. So thus what we today have are a very, very wider law, especially from the BNS as well as IT Act, especially 43 or 60 66, I think just if we give a judicial interpretation, a meaningful judicial interpretation, we can cover various forms of cybercrime, some of them which we're even not aware of as on today. So when offenses committed through, as I said earlier, automated vehicles or drones, etc., or AI devices, deepfakes, can be covered under at least some of these clauses. So hence provisions are more, but what we of course require is a meaningful interpretation, not a vague interpretation like what had happened in 66A was because even Supreme Court says it was more abused than used. So as long as we meaningfully use, we have extremely important provisions. So that's in brief about the substantive provisions from the three laws. If there are any questions, I'll be happy to take.
Thank you so much, Dr. Nagaratna. You have explained the intricacies of the various provisions of the IT Act, the BNS, the POCSO, and also the scope and practicability of their application. You have very candidly explained by way of examples, some of which are even scary, I would go to say, and with such clarity, which would be so much useful for all of us being members of the judiciary, the police officials who have to take up the matters of investigating these cyber offenses. So thank you so much, and I think we would all go back very much enlightened on the subject by what Dr. Nagaratna had to say today. Thank you so much.
Thank you, my lord. We are thankful to the Honorable Chairperson, Honorable Justice Srimati Soni Srivastava, and to our expert speaker, Dr. Nagaratna, for facilitating us in having a better understanding and concept of the subject and giving us a very detailed and exhaustive list of all the provisions that will deal with the cyber laws. I believe these provisions should help the police officers in correctly applying the law to the cyber crime which is being reported to them. Most of the police officers who are present here are SHOs of cyber crime police stations, so that will be helpful for you in applying the substantive law. And as far as judges are concerned, that will also help us in interpreting the exact provision of law that needs to be interpreted as far as cyber crime is concerned. Thanks a lot, ma'am. Thanks a lot, my lord. So with this, we come to the end of the first session, and we'll have a short tea break of around 15 minutes before we regroup for the second session, second technical session. So I'll humbly request the honorable judges to be in tutorial 1 for a short tea break. Our esteemed guests also will be in the tutorial 1. And for judicial officers, participant judicial officers, we'll have tea in the cafeteria. And for the police officers, we have a place just besides this auditorium, behind the auditorium. So we'll regroup after 15 minutes for the second technical session. Thank you so much. A very good afternoon and warm welcome to all the honorable dignitaries and to the respected participants to the second session of today, second technical session. We now begin the second session by addressing legal and contemporary issues in cyberspace, from data protection and freedom of speech to jurisdictional issues and intermediary liabilities. In an era which is shaped by data, privacy, and platform responsibility, this session explores how law keeps pace with the fast evolving digital realities. These issues, from free speech to intermediary liabilities, jurisdictional puzzles, these issues sit at the heart of modern cyber jurisprudence. This session will be chaired by Honorable Mr. Justice Saurendra Pandey, Judge, Patna High Court. His Lordship, before being elevated to the bench, had a roaring practice and was also the learned counsel for CBI. And to speak on this topic, we have today with us Professor S.V. Joga Rao. We are privileged to welcome Professor Dr. S.V. Joga Rao, a postdoctoral research scholar in healthcare, law, and ethics. With nearly 3 decades in academia, including a distinguished career at the National Law School of India, University, Bangalore, he now actively practices as an advocate and a solicitor. Dr. Rao is renowned for his expertise at the intersection of law, ethics, and healthcare technology, and continues to contribute as a visiting professor and institutional ethics advisor. He is also a recipient of the very prestigious Max Planck Fellowship from Germany. May I now humbly request Honorable Mr. Justice Saurendra Pandey and Professor Dr. S.V. Joga Rao on the dais to please speak on the subject. Sir. I now request Shri Vinay Sankar, Additional Director, Bihar Judicial Academy, to please felicitate Honorable Mr. Justice Saurendra Pandey. Thank you. I now request Shri Kumud Ranjan, Assistant Director, Bihar Judicial Academy, to please felicitate Professor S.V. Joga Rao. Thank you, Kumud. I now hand over the dais to my lord.
Thank you, Pranav. Good afternoon, everybody. Honorable Mr. Justice Ashutosh Kumar, the Honorable Acting Chief Justice of the Patna High Court, Honorable Mr. Justice Vipul M. Pancholi, JD1, Patna High Court, Honorable Mr. Justice P.B. Bajantri, Judge cum JD2, Patna High Court, the Honorable Judges, my brothers and sister, and the learned AG, and also the Chairman, Bihar Judicial Academy, Shri Purushottam Mishra, Director, Bihar Judicial Academy, Shri Binay Shankar, Additional Director, Bihar Judicial Academy, all the stakeholders, the policemen who are here in this session, which relates to the jurisdictional issues being faced in the cybercrime. Respected dignitaries, all the esteemed panelists, the distinguished guests, Honorable Professor Sir, it's a matter of honor as well as a responsibility that I have been given this chance to chair a session which relates to cybercrime, which probably, what I know and I feel personally, that we are not only as a judge listening to the crimes which is happening or people who are there investigating about them, but we are also falling for those crimes. We are victims of those crimes also. And I would later share that I was also a victim of a kind of cyber crime, but I managed to escape. Probably I was enlightened earlier by somebody, and I managed to escape. So the session primarily is with regard to the evolving jurisprudence in cyber law, jurisdictional conundrum in cyber law, liabilities of intermediaries, and privacy, data protection, and freedom of speech. To begin with, what I have seen is that as far as India is concerned, it faces numerous legal and contemporary issues in cyberspace, primarily revolving around cybercrime, data protection, and the balance between the regulations and the freedom of expression. Key concerns include the cyber stalking, cyberbullying, financial frauds, which we are all facing, and evolving nature of cyber stacks like the ransomware, malwares, which are being thrown at our phones, computers, whatever we are using. The legislation was very proactive, I would say. Way back in 2000, they enacted the IT Act and the Digital Personal Protection Act recently in 2023. They were designed to address the issue, but challenges remain to get adapted to the new technologies and ensuring their effectiveness. Because as our previous speakers, our Honorable Acting Chief Justice had also pointed out that the criminals, as far as cybercrime are concerned, they are probably way ahead of the investigating agency or even the laws which we are making. So probably, sir, would be referring to those issues. And coming to the data protection and privacy, this is again an issue which probably is being faced by everybody, and the act which was framed in 2023, the DPDP Act, to protect the personal data. But the concern, to my understanding, remains about the potential of the government overreach and the balance between privacy and that national security. So that concern, probably to my understanding, still remains, and probably sir would be highlighting it. Freedom of expression versus regulation, that is one aspect which needs to be, that's another area of concern. Because the legal framework which we have, that struggles to balance the need for regulations to combat the harm with the right of freedom of speech, the controversy surrounding Section 68 of the IT Act, which was ultimately struck down for violating freedom of speech. The other aspect which I have also observed was the fact that the cyberbullying and the harassment which is taking place, this, and which includes cyber stalking, which generally is the adolescents are affected with. So that's an increasing concern, and the IT Act addresses these issues with provisions for punishment and everything. But instead of the menace going down, we have seen that we are actually struggling till date to cope up with the technology, and to the extent the criminals are way ahead of us. Now, as again had been talked by the previous speakers, with regard to the new technologies like the blockchain and the AI introduce complexities with this current legal framework. But again, I would say that does not actually fully address the issue. As far as the jurisdictional challenges are concerned, the cross-border nature of cyberspace makes it difficult to determine. I'll share at this moment, I had come across a case where I was hearing a regular bail matter, and the lawyer showed me that, sir, look, ये phone number जो है वो +92 से था, तो ये phone पाकिस्तान से आया है, तो ये यहाँ का नहीं है सर, हमको झूठ फंसाया गया था. I am not concerned with, because he was referring to that number of +92, which obviously is of Pakistan. So I tried to make him understand, which I had understood by somebody else, that it it has nothing to do with the number going to Pakistan, because the technology they are using, all these people are there among us. All these people might be in our neighborhood, as we have seen our infamous district Nalanda has taken over even Jamtara now. Probably, so we don't need this kind of access to actually make these calls from beyond the borders. It is actually the technology which is being used, and nothing to concerns as far as the cross-border or things like that. People, they can't take this issue that it is not related to a particular region, and that because of this vulnerability, that it can go beyond regions. In cybercrime, you don't know where the person is sitting. Like the physical crimes, we know that the person stays here or the person is there around. But in cybercrime, you just can't define. You can't define the jurisdiction. So that's one issue which is again very crucial. The liabilities of the intermediaries, that is a question, because generally people get away with that. The IT Act, though, provides safe harbor or protection to intermediaries like the social media. They don't have protection, as the previous speakers had just said, that people are getting away saying things. They say that they have just circulated, they have just forwarded. The Professor Nagaratna had issued that there is a provision in the Act to look into it, and just because people just can't say that they have circulated it because it has been forwarded to them. Even that circulation is a crime under the Act now. So that is one part where the intermediaries, that the due diligence has to be exercised, and that needs an area of concern which needs to be, that is actually self-regulation. And now, if I, at this moment, I can refer to one, I'm taking leave of my Lord's, the Acting Chief Justice story. I had an occasion to witness a Netflix series that was Adolescence. Probably I don't know if anybody had seen it or not, but I would recommend, as far as the young persons who are, how they are being pressurized, what they are going through in this digital age. They are the social media, the anxiety, the pressure of the social expectations. That it's a beautiful Netflix series, and it relates to the cybercrime. That I can only give a hint because I won't be revealing the facts. So this series, it just came to my mind when this subject was, I saw the subject, this series automatically came to my mind. So without taking much time, we have an expert as our resource person for the session with us, Professor Dr. S.V. Joga Rao. He is a visiting professor at the National Law School, a prolific author and a seasoned communicator. And what I just learned was that he has been conferred globally acclaimed and intellectually coveted Max Planck Fellowship of Max Planck Institute, Germany, sir. Congratulations on that, sir. So without taking much time, I invite Dr. Rao to take over and just take us through the entire topic. Thank you.
Pranams to all of you. Thank you so much for the kind invitation and the kind of hospitality. I did, as an academician and as a practicing lawyer, attended many conferences. Many a time what happens is, inaugural function is a matter of formality, and technical session chair is a matter of formality. But today what I learnt is, the way all the judges, particularly Acting Chief Justice, he spoke during inaugural address, Justice Pancholi, Justice Bajantri, and now Justice Saurendra. Excellent. I am so happy. I think this is the kind of transformation that is required. so that all the participants, they are on the same page with the common purpose. I just would like to make two observations. What I notice in the hall is, right side almost 6 to 7 rows, I see young judicial officers. Naturally, next few not very old senior judicial officers. And first 2 rows, I must tell you, relatively younger High Court judges. Left side, when I see all police officers, they are very young, followed by our judicial officers. I think this is the most important thing, because the subject matter what we are discussing today, I think the younger generation need to take the lead, either in terms of judiciary or in terms of police investigation. The future, please remember, the day is not too far where evidence remains only as an electronic evidence but not in any other form of evidence. Second observation. I remember Karnataka Judicial Academy, one of the training programs for inducting judicial officers. They invited me for one session on cyber law XYZ. As usual, the time was limited. Then I said, over a cup of tea, I just want to interact with judicial officers. I just want to know what kind of challenges, limitations they face. I must tell you, at least 5 or 6 inputs have come, which are very, very significant and a great learning for me. One judicial officer mentioned very clearly that the problem what we face is the kind of jargon, the kind of vocabulary that is used while explaining technology. I did not study cyber law. I did not have any training in cyber law. But as a judicial officer, I needed to interpret and make a decision. That is the challenge I face. Second, the most important, lady judicial officer. She said, the interplay between law and technology is the challenge for me. We study from a textbook or a case, etc. But when it comes to me as a judge to decide, I find a challenge. Which means hands-on experience is not there. That does not mean for other offences, whether it is BNS or etc. No, you have training. But when it comes to this, conferences like this are very, very important. My dear friends, one thing I want to say, many a time, if the law is to be only in the light of white and black letters, that is at one level. But as and when there is a need for interdisciplinary approach, we take a step backward. Not you as judges, even as teachers, even students. I think that trend must see a landscape change. Because everything is a matter of interdisciplinary now. Finally, that's where I mentioned to Honorable Acting Chief Justice that his emphasis on vocabulary is very, very important. The way technology changes, please remember, vocabulary also changes. It is not regular routine English, something else. A technocrat or an engineering student or a professor may understand. But what about lawyers? What about honorable judges? How they can? I think that's the gap which needs to be bridged. It is not just a one-time activity, it is an ongoing activity. For the simple reason, technology changes every day. The way we thought about artificial intelligence 1 year back, now the changes what we are experiencing, it is something unbelievable. In the light of this backdrop, my presentation cum interaction is going to focus on 4 important themes. Evolving jurisprudence in cyber law, jurisdictional conundrum. Even today, I don't think, barring a couple of judicial decisions from the first world and a couple of judicial decisions from India, I don't think there is a kind of, in quote, a concrete principle to look into. Therefore, that is something, that's what even Justice Saurendra just now he mentioned. I am going to look at it. Then followed by liabilities of intermediaries. Our life in terms of technology driven is so substantial. I agree that we 65 plus, 60 plus, we may be bit lesser. But the entire population, younger generation, for them, that is what is the need of the hour. Therefore, we need to really look into liabilities because a lot of changes are there. And finally, privacy, data protection, and freedom of speech. All the four themes will be looked at in terms of case study and a critique. The critique is only to share my viewpoint. It is up to you to either to agree or not to agree, because in a democratic world, dissent is the voice of progress. That is the reason why it is necessary to have a dissent, but rationalized. To begin with, Professor Nagaratna did make a mention in her presentation, which I felt is very, very important. The scale of the cyber activity and the impact it causes, I think it has reached a stage where it is not merely number, but the extent of impact. WannaCry is a ransomware. A ransomware which is a worm which replicates itself and replicates other data, impacted 150 countries in the world in 4 days. The micro detailing, if you look into WannaCry, you will be surprised to know even the ambulances were rerouted because the route of ambulance was based on GPS data. Because of the ransomware, the rerouting took place. As a result, potential lives lost. That's the impact. Now the question is, there are various ways of looking at whether the current law deals with it or not. I think that's what Professor Nagaratna explained. The other important thing is, addressing, penalizing, investigation, judiciary comes also as an important dimension. But for me, the most important thing is, how do we prevent? If an offense committed, investigate, brought to book the culprit and punish, that's one way. But when it comes to the technology driven, the kind of impact what we are talking, I think prevention we need to. Prevention has a very important technology role. Advancement of technology, as we have seen, is at an unprecedented pace. Premise of cyber law must adapt to address these unique challenges. I need not tell you about the pace of law making in this country. As a result, it is inevitable that we cannot keep pace with the technology. By the time the law is made, technology multiplied. It is not only technology. I think A.O. Hume, he made a very interesting observation in the 18th century. Law cannot be, because whatever said and done, the process is that. In terms of technology, we need to find a solution as to what needs to be done. Digital threat landscape, if we look into, these are all not India alone, no, internationally. First thing is, evolving nature of technology inevitably leads to new opportunities for attackers. You remember Section 300 Clause 3 IPC 1860? It was interpreted in 3 important cases. The interpretation is very, very simple. Intention to cause death, intention to cause injury whether that injury is sufficient in the ordinary course of nature to cause death or not. That's all. That is the interpretation. And Honorable Supreme Court made it very clear, saying that intention to cause injury is subjective. Whether that injury is sufficient is objective. Accordingly, etc. In terms of 300 clause 3, the only difference would be I may use a sword, some other person may use some other thing, poisoning, etc. These are the things. But technology is not like that. Technology changes in such a manner, as a result, even the attackers, they are also equipped with the new forms of technology. I'll just give an example. Artificial intelligence and machine learning. In fact, in machine learning itself, there are so many subtypes. If we look into majority of the cyber criminals, they are more equipped with AI to commit the crime in a nuanced manner. Therefore, it is necessary to, new technology needs to be, and we should be able to understand. These are the couple of things I have selected in terms of the current contextual scenario, the landscape. In my opinion, cyber law must necessarily address these emerging trends. Artificial intelligence and machine learning, automotive cyber security, mobile devices, targeted ransomware, state-sponsored cyber warfare, supply chain, distributed denial of service, DDoS, Internet of Things, IoT, and cloud services. These aspects constitute business, transaction, personal usage, including the state infrastructure. As a result, if these trends are not addressed, I don't think we are in a position to really locate the cyber criminal and address what offense he or she has done. What is artificial intelligence? Intelligence which is artificial, which means mimicking like human being. That's all. What a human mind does, the machine does in the light of algorithm. That's what is. That is one thing we understand. Machine learning also we understand. For example, a pregnant mother is subjected to various types of scans depending upon the fetal age. That is what is the established medical norm. Scans are conducted, reports are developed by the doctors who are experts in that. If AI tool is there, if one person 100 scans per day, AI tool 100 scans with more accurate and less human error can complete it 1/10 of human time. That is artificial intelligence. And healthcare is one area where AI is used prominently and predominantly. The issue is not will it substitute. I'm sure you must have seen the American developments, particularly pre-election era, whether AI substitutes human mind. Many people said no, it cannot be and it should not be. But many people have shown it is possible. Sculpting the way AI tool does is much more than a human mind does. Our own law school students or anywhere students, their project assignments, the way the problem we face, it is not very clear whether the student has written or the tool has written. In that context, my dear friends, I don't dump down the advantages of artificial intelligence. There are. For example, as a lawyer or as a honorable judges, whether AI, yes, definitely it is. I'll give 3 examples. For instance, a particular legal notice is to be developed. We get the inputs from the client. With AI, I can generate a draft within no time where with additional oversight, I firm up and finalize. Similarly, a kind of research to this issue, what are the precedents with X, Y, Z, AI does it more, which means at the end of the day, the human effort, human endeavor in terms of time gets shrunk. That is the advantage. Therefore, artificial intelligence and machine learning, the way it benefits, but however, as I told you, it also benefits the criminals. I think that is one thing we need to take note. Automotive cyber security. I mean, we are getting into the world, Professor Nagaratna made a mention, that is driverless cars. We did reach that stage thanks to Elon Musk. I am sure in India, anytime we may get the car. But even though driver-driven cars, they are mostly dependent on technology. The way the driver assistance systems, etc., everything is a matter of software. As a matter of that, the hacking risk. If that takes place, please remember the kind of inevitability in terms of the destruction, disruption is unbelievable. Then comes mobile devices. Today morning also there was a mention how mobile is everything for us. As a result, for a criminal, mobile is the important source. Either your banking detail, personal detail, you name anything. Digital arrest, there was a mention, but I wanted to mention this particular thing. January 15th to November 15th, no, 1st January to 15th November 2024, 92,323 cases reported. 2,140.99 crores lost in a year. Friends, now various banks, RBI, lot of public awareness, lot of information, etc. But prior to digital arrest, there were many other forms. You get a mail from one Nigerian. He says, my funds got stuck. Therefore, you share your bank details. I will transfer. You keep 30%. You give me 70%. That's more than enough. Like that, there are so many mails, scams, etc. Now, those trends have evolved to digital arrest. How many retired school teachers, they lost money, their hard savings. Very few people's savings could be saved. One such incident came from Gurugram, how the bank manager identifying the person when she wanted to draw 20 lakhs at a time, then she felt there is something going on. But the woman doesn't share because the kind of mandate, the kind of threat has been given. I think that is one. No doubt the public awareness is very important. There was a mention about DGP. I can tell you, sir, our own community lawyers, how many people? Lawyers, ED, or some other agency, Delhi police, some other police. First of all, I got to know one thing is that my friend, I don't want to name any details, I was really worried why he felt vulnerable. Is there something? I mean, honey trapping, the recent trend, many people say there is something, therefore it gets into that level. But my lawyer friend told me nothing. Then I said, you are a lawyer, you must be knowing. Then he said, no, my children, my wife, this, that. I mean, it went on to a different dimension. Therefore, digital arrest, the incidents definitely reduced, but not avoided. Targeted ransomware, particularly remote desktop protocol. I am sure you are aware, for example, my desktop can be invoked, used, stored, emails, everything from a different remote desktop. There is a particular app that requires to be done automatically. Many a time this is being done without our knowledge. In fact, we do not know what is happening in our computer, but the remote controller, he or she knows. As a consequence, the brute force, that is word they call, they deploy, and it may lead to not only stealing, destroying, or distorting, many consequences happen. State-sponsored cyber. Indian context, you just look into incidents, 85,797 increased to 2 lakh and odd in 2023. That is a ministry confirmation. Which means educational, governmental, defense, other institutions of government of India were subjected to state-sponsored cyber warfare. Supply chain. This is one very, very particularly those in business transactions, this kind of service. I'm sure you know, anything we can get within 10 minutes. Big basket, that is the advertisement. Zepto, that is the advertisement. Except gold and diamonds, everything else they will. 10 minutes. The situation we have reached a stage where all the things are matter of supply chain, third-party vendors. As a consequence, what happens? The attackers can exploit the MSPs, that is, managed service providers, because their systems are not that robust. Consequently, the entire thing will be. Distributed denial of services, this is another way of a particular distribution in terms of various multiple. Their distribution networks are subjected to attack. As a consequence, please remember, the entire situation leads to unbelievable consequences. Loss of data, tampered data, or destruction, etc. Then comes cloud services. Alibaba, you know Alibaba? Yes. Not our Alibaba. No, I just want. No, many of China. 2021, the kind of impact, it is because of misconfigured cloud environment. Cloud has become like any other guest house for us, because all our information, all our data, we put it in the cloud. And there are people who serve the cloud-based data storage. As a consequence, there are many advantages, and if the criminal does it, there are advantages for the criminal as well. Therefore, we must look into in what way the cloud. I am sure the data protection, that is digital personal data, has a couple of provisions in order to ensure government of India has control over the data. Because unless we have the control, we will not get the jurisdiction if there is a problem. I think to that effect, these are the trends which make it very clear in terms of the cyber law emerging. And I think our law must really take note of and ensure. My dear friends, BNS, I am very critical. I appreciate the kind of effort, etc., but I am very critical for the simple reason, according to me, a substantive penal code shall not mainstream special offences into it. Special offences are there are special enactments, those enactments will have different jurisdiction, different enforcement, etc. But the moment you mainstream, the substantive penal code is subjected to various dilutions. I think that's where, not now, I am sure as and when the honorable courts get an opportunity to interpret, we will get to know. Same thing with regard to the jurisdictional aspect. In cyberspace, geography is a matter of history. There is no geography at all. Where is the geography? As a consequence, as Honorable Justice mentioned, how do you identify? See, jurisdiction is very important for criminal offences, no? Even civil disputes, contracts, so much of civil, trade, commerce, so many. How do we decide? I think to that effect, the most important thing is we need to understand the global nature of the internet, where cyber crimes and disputes can occur across borders, making it difficult to determine which country's laws and courts have jurisdiction. When we compare to the internet and the real world based, I think the challenges are very clear. For instance, multiple jurisdictions. Depending upon you take a particular crime. For instance, server is in one country, the computer source in another country, the information posted will affect people from a different country. In such a case, which country, which court will have jurisdiction? Multiple jurisdiction. Then comes extraterritorial application of laws. To that effect, BNS, in a slight change, they did indicate. Earlier Indian Penal Code also mentioned, we need to look into the extraterritorial application. Even though there is a provision which provides extraterritorial application, but who is going to enforce that? If there is a country where a diplomatic relationship, etc., there is a different situation. But otherwise, the jurisdiction is only on paper, but not in terms of a practical solution. Then comes enforcement issues. Premise of territoriality is inadequate. We don't have that. And transcending boundaries. It is not one country, two countries, the multiple countries. You look into all these, whether it is supply chain attack, DDoS, ransom, this, that, etc., possibility of multiple countries where what is the basis on which you decide which country should have jurisdiction. If India has to have jurisdiction, what needs to be done? There are many cases. For example, WannaCry impacted a particular hospital group chain in India. But WannaCry born in North Korea. North Korea, you know. From Russia, how many? Therefore, ultimately it boils down to more of a diplomatic relationship rather than a strict enforcement of law and enforcement. Similarly, are there no judicial? Yes, there are. As I mentioned, Zippo is one and Calder is another one. The two important US Supreme Court judgments. Of late, there is a drifting away from Zippo to Calder. That also I'll explain. America is known for long arm jurisdictions. County to county, state to state law and federal law. If you look into, the state is given jurisdiction even though they don't have by virtue of this particular interpretation. For instance, Zippo you take. Zippo mainly dealt with a particular portal-based service registered in a particular state but renders a service in another state. In that state, the person who purchased or availed service has a grievance. The question is whether a suit can be filed there or the place where the particular establishment is there. Courts have no hesitation in saying that depending upon the website activity, websites active, passive. If website is active, transaction take place, even though the person is in a different state, the person has availed service, the court has jurisdiction there. I think Zippo was in that kind of period where the portal-based services were at a minimal level. Now everything is a portal-based service and every portal is an active portal. For example, I have a portal. It is not just merely what I say, but I invite others to say. In that way, it is highly interactive. Therefore, Zippo appears to be no longer. Then Calder, the new interpretation, they said, no, you look into effects. If the person in a different state faces effect, which is adverse in nature, that state will have jurisdiction. I think currently this is the trend that is going on, and even in Indian context also, some of the Supreme Court, particularly I am referring to the Google case, Supreme Court made it very clear in what way it can differ from Zippo and attract Calder. Indian experience, let us look into. For instance, subjective territoriality, 1-4 BNS. Earlier it was 2, now it is 1-4. Then objective territoriality, effects doctrine, section 199 BNS. Earlier 179 CRPC. BNSS, Nagarika. Section 15 BNS. Section 199 BNS and Section 75 IT Act. If we look into subjective territoriality, objective territoriality, what do we mean by that? Within India, any person, that is at one level. Any person committing an offence as envisaged in Indian Penal Code or BNS in a different country. In such a case also we will have territoriality. Now, how far these provisions enable to find a solution to jurisdiction conundrum in cyber law. 2023 National Judicial Academy, Bhopal, has convened a very interesting judicial officers conclave, where one of our NLS students, who is a senior counsel in Supreme Court, Sajjan Puvaya, participated in that. And he was the person who collated material, etc. That material is available online. I will share with you. You can just have a look at it so that where two important points have been raised. I think the points are still the jurisdiction we are not able to, for the simple reason there is no clarity in terms of judicial interpretation. While taking note of Indian provisions, we may arrive at a conclusion, but without effective enforcement. In order to show how effectively enforcement can take place, the conclave looked into one particular thing, India versus US. They said it all depends upon whether the government will be able to. Can we give? Then they said, no, in certain respects, for instance, defamation, hate speech, or any posting targeting a religious community, blah, 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 blah. In such a case, we can ask the government to block it instead of enforcing and having a jurisdiction, etc. It's under Section 79 of ITI. I think these are the measures they discussed, which to my mind, they are very, very realistic. But however, still we need to really look forward to a judicial interpretation or innovative judicial test. Cyber defamation, this is what I mentioned to you, to block the indicated websites in the public interest. Potential solutions always, 20 years ago also we have discussed the same thing, 20 years ago. New jurisdictional principles responding to evolving characteristics, focus on effects, a lot of universal endorsement is taking place now. Focus on effects. And international cooperation, I think the geopolitical situation has changed so much, international cooperation is kind of, I don't know whether it is possible at all. And harmonization of laws across borders is something very, very important. Liabilities of intermediaries. Simple, very, very simple. Whether we talk about internet service providers, social media platforms, online marketplaces. Online marketplaces. Say for instance, Amazon. You want to buy something. Amazon has a marketplace and a seller's place. Marketplace means different vendors come and display their products and they sell the products to public directly. Seller's market means Amazon's product will be sold on its own platform directly with that is the difference. In such circumstances, the simple issue is, if there is a problem as to either requiring exchange or a quality or blah, 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 whether the portal can be made responsible. Secondly, the most important, a kind of, you invite people to create content and the person writes something against India and that is posted. Now the question is, can we ask the portal to take away? Can we create a responsibility of screening, etc., etc.? I think these are the questions, intermediaries. The 2009 2009 post situation is different. For instance, if we look into, these are the, safe harbor was the principle, which means intermediaries, they are not subjected to any kind of thing, etc. To protect intermediaries, Section 79 exempts intermediaries from liability, Rule 3, IT Rules 2011. But those rules have been replaced by 2023 rules. Situation is now different. Amendment to Section 79 expanded the intermediary immunity significantly. This is post 2009. As a result, what happened? Either to remove the content or disable the access if it is having actual knowledge. If the intermediary has knowledge, then it can be. But otherwise, in other words, the immunity scope has been increased. As a consequence, we got into a particular situation of Shreya Singhal. Shreya Singhal, I personally endorse the rationalization, personally. For the simple reason, if I am the platform and another person writes a content and posts on it, if the platform is to be given a legal duty to delete, will it in any way embark on the freedom of speech and expression on the part of the content writer? How do we do it? Honorable Supreme Court felt giving that kind of opportunity or creating a duty on the part of the platform is not appropriate. Then they said, if there is a court order, it can be done. And then the court said, which I think is very, very important, the concluding sentence, however, the court must adhere to the limitations envisaged under 19 clause 2 of the Constitution of India. If the court passes an order and on that base it can be done, no problem at all. But while passing the order, Honorable Court must look into 19 clause 2. I think that is something. As a consequence, what happened? Indian law did not take a balanced stand. Now the situation is different. For example, 2021, our rules have been changed. The rules have been changed in such a, what you call substantive level. For instance, due diligence is necessary. Privacy policy must be not only announced, but get the informed consent of the person who is the user. Grievance redressal mechanism, obligation under user management, self-regulation, etc. But the impact, though it is not been tested, but the impact I personally feel is on fundamental rights. Because couple of situations, what the law envisages, I think is very, very crucial. I agree that, of late, every one of us, we are aware, two-judge bench of Honorable Supreme Court judgment has become a topic of the country with regard to Honorable Governor of State of Tamil Nadu. We have heard Honorable Vice President what he felt. On the other hand, what Supreme Court Bar Association President Senior Counsel Kapil Sibal in his retort, what he said. And yesterday's newspaper carried a very interesting article, Acharya, the former parliamentary secretary, what he felt. I think that really gives a very important thing, the dynamic developments that are taking place involving Supreme Court and a judgment of a particular nature. I have not seen the kind of thing of late. I am really happy because in a democratic country, the judgments must create the dialogue. I may not agree with you, no problem, but I want to say, and I must be allowed to say, within the realm of the, I think to that effect, I am sure every one of us will have our own opinions, but the opportunity is something unbelievable. The reason why I am saying is the potential impact on fundamental rights also same thing, in which I don't think we can, in fact many of them ask me, no, is it possible? I said, I am also a common man in this country. Certain things only I can say. No, why you cannot say? Because I need to think about my family. Every one of us. If given an opportunity to express with that kind of thing, I am. But otherwise, even I. That is the reason why, in a conference like this, where it is required to be mentioned in the light of this particular thing, I. Then comes the concluding leg of my presentation, which is very, very important. And particularly, I like that phrase, free speech. Of course, bound to be free speech, not like YouTube discussions. No, no. It cannot be. But that does not mean I can't express what I want to say. Within the bounds of constitutional, we have to. To that effect, I think we have a lot of, there is no concrete, no doubt IT Act did make a mention, etc., but there was no comprehensive legislation data protection because of two reasons. 2017 Justice Puttaswamy, where privacy is not merely privacy vis-a-vis the individual, family, autonomy, body, etc. No. What about my data which I create? Data privacy must form part of privacy. I think that's where. Second, the most important thing, every one of us, we know that we create data, we generate data, but as sir very rightly said, we don't know how to handle the data. And many a time the data, what you possess, strictly you are not in possession, somebody else is in possession. I think that's where data protection law in this country is so important. And what actually happened, I think three I'll give. Aadhaar and passport numbers of individuals registered on CoWIN portal, COVID-19 vaccination, leaked. Number is kept under. In fact, when once I got to know, I asked my son which vaccination I took it. Because all our details for the open glare. Second, a leaked data uploaded on GitHub. I'm sure you are familiar with GitHub. No? It's a platform recently AI generated. Recently, Hyderabad, a particular forest, etc., it was under Supreme Court scrutiny. Gachibowli. And to that effect, a particular officer uploaded a particular paint which was not authentic. That is how. And that's right. As a result, users' data, what kind of data? Employee Provident Fund Organization, millions of people, BSNL users' data. And finally, 110 million customers' personal information from Mobile Valley, MobiKwik, UPI. Advantage is there is no doubt in that. But you are in that space where a criminal will be able to access your, that's what it is. As a result, data protection, we need to create law to say, if you are in possession of data, what you should do. If I take your service as a data custodian, what rights I can claim? My dear friends, the premise is very, very important. Personal information, jurisdiction extends to data processed within India, regardless of processor location, and also applies to personal data processed outside India. I think that is something we need to. There are two pivotal principles, purpose limitation, the purpose for which I am availing. I'll give an example, my medical records. See, because of my age, all my medical records, I want it to be digitized. I go to a particular thing, I say, as and when I am traveling, in such a case, if I have any kind of thing, there the doctor will be able to access the kind of thing, etc. Purpose limitation. The data minimization, the person who is going to store my data, keep the custody, can only use it for one particular purpose, on the part of the user and on the part of the data. Personal data can only be processed for predefined legitimate purposes with informed consent. That's called purpose limitation. Informed consent, if it is not there, you cannot do it. Similarly, data minimization ensures only necessary data relevant to the declared purpose is collected and processed. This is the duty on the part of the data collector. Data principles, please remember, are the users or consumers have certain rights. Access, correct, right to lodge complaints. The data fiduciaries are the people who are collecting, storing, and allowing access to the data. For them, they must, and stringent statutory duties must be. Data Protection Board, please remember, is an independent, quasi-judicially conferred with powers of civil court, a board which enforces A complaint can also be filed because a redressal grievance mechanism is also part of the code. Proposed rules are under scrutiny and the exemption for journalistic activity is taken away. This is where I feel, I know India is witnessing a great deal of scrutiny now when the rules are being drafted. Last 2 years, personally I felt journalistic exemption taking away is something not acceptable. What is the journalistic exemption? An investigative journalist who writes a story or creates a particular thing, etc. Till date, journalist is given that exemption under data protection. Now it says you must get informed consent of the person. Suppose I wanted to investigate a particular MP's, MP as a role and MP is business. I can't do it now because I will never get informed consent. I think earlier 3 drafts, the exemption was included, but the final act when it is made, it was taken away. In a democratic country, I know, my dear friends, one thing my brother always used to say, no, don't you think that it depends upon who owns the houses? I am talking about the media, for example. It all depends upon who owns the media, because what a media person can speak depends upon who owns the media. My dear friends, that's a very interesting question. And I think 22, 23 we have witnessed. And I am sure 24, 25 we will witness much more. I think that's where the phrase I read out in the ransomware, brute force, I think in a democratic country, particularly in terms of franchising, elections, etc., brute force is not. What we require is an able opposition. That's the need of the hour. And I think that's where we need to really look into, see in what way the data protection, on one hand you protect the privacy, on the other hand, freedom of speech is not crushed. Normally in National Law School, one thing I follow, I am sure Professor Nagaratna also, because this is the tradition. If there are questions from the audience, it's fine. If not, we will start posing questions. Yes. First question I must pose to him. Go ahead.
With the permission of the chair, we allow the participants to put their questions.
Please do that.
A person with a mic will be there to assist you, and then you can put in your question after identifying yourself.
Good afternoon, sir. I want to know what is satellite surveillance system and how to regulate it.
Supply chain.
Respected participant,
Just a second.
you need to identify yourself before putting in a question.
First, introduce yourself. You are not audible. Please keep the mic close.
SDGM Samastipur.
Yeah.
I want to know what is satellite surveillance system and how to regulate in India in this scenario, in digital age.
Satellite surveillance. Okay. Just to respond to your question, I just want to know from you. Use mic.
Yes.
In what respect you are asking? Because the question is quite broad. That is the reason why. Satellite surveillance has so many issues. Can you just specify one or two?
If any cyber terrorist or any unauthorized person may may
attack.
no. May doing any work against personal data protection. Personal data, how breach personal data, how to regulate it.
I would request, you can speak in Hindi. You can speak in Hindi, try to explain that word.
I want to say, यदि कोई व्यक्ति या अनऑथराइज्ड पर्सन सैटेलाइट सर्विलांस सिस्टम से यदि किसी व्यक्ति के पर्सनल डेटा को हैक करता है या उसमें कोई उसको पर्सनल जो प्राइवेसी उसको ब्रीच करता है, उसको कैसे रेगुलेट करेंगे?
Good. I am really happy that you asked this question. For your information, even now we are experiencing such attacks where the sensitive information or the data is either breached or compromised or kept in public. We have laws which deal with that. But I want to clarify, in terms of cyber law, I mean IT Act or BNS, etc., definitely, there is no problem. But when it comes to Data Protection Act, slightly different. In Data Protection Act, where my data is given access to another person, and that person takes the responsibility of storing, collecting, keeping it custody, etc., etc. In such circumstances, what he can do, what I can do. Suppose, in the light of this, the person who is custody of my data, somebody else breaches. There is a possibility. In such a case, either BNS or the IT Act we have to invoke.
I am focusing on surveillance based on satellite system, how to regulate it. Surveillance, सैटेलाइट सर्विलांस सिस्टम, सैटेलाइट से यदि किसी व्यक्ति के पर्सनल डेटा या किसी भी चीज़ों को ब्रीच किया जाता है, उसको प्राइवेसी का उल्लंघन किया जाता है, तो यदि कोई सैटेलाइट सर्विस जो सिस्टम है, एक तो होता है कि आमतौर पर कि मोबाइल फोन से होता है, दूसरा है कि रिमोट तरीके से, जो आज जैसा आप बताया कि रिमोट डेस्कटॉप प्रोटोकॉल है, तो उस हिसाब से कैसे उसको देखेंगे, उसको कैसे रेगुलेट करेंगे, ये जानना चाह रहा हूँ आज के युग में.
Now, if it is through the means of either mobile or computer source, anything, the existing laws are there, they will take care. But you are asking about regulation. Regulation, the laws are there, but the laws with some challenges. For example, jurisdiction, how do we decide? If the person is from a different country or the server is in a different country, in such a case, we don't have ready-made answers as of now. We need to really look into. Maybe the Calder case of US, if it is followed, the effects doctrine, because there is a possibility either the adverse effect is followed or experienced by people in India or Indian people in some other country. Either this way or that way, I think there is a possibility of jurisdiction, but otherwise there is a need for clarity even today.
I have also one question.
Please, where are you? Yeah.
Yes. We were just talking about supply chain network, which is very much about logistics, and most of the time there are too many countries are involved in that process.
Correct.
And in addition to that, when we are talking of the geographical and the territorial limits in cyber law, can you little explain on it?
What is the second sentence you said?
The geographical and the territorial limits,
yeah.
Jurisdictions actually.
Okay.
The word should be jurisdiction. So I just want a little light on this, like how the supply chain network, where a lot of countries are involved, the data is being conveyed from one country, one territorial jurisdiction to other, and at the meantime, how do we maintain that non-availability of the particular geographical territorial jurisdiction in cyber law?
Yeah. In terms of what we have, either BNS or in a way BSA, because section 1 deals with before any court, okay, or IT Act, etc. There is something subjective territoriality if an Indian is involved, suppose if an outsider is involved, committing an offence which is punishable under Indian law, the law says the court has the jurisdiction. But how do we enforce that? For instance, the BNSS, for the first time, they have introduced one very important amendment where prosecution of an offender does not require physical presence. I hope you are aware. BNSS, that's what they have introduced. Because unless you fetch the physical presence of the accused, how a fair trial can be conducted? This amendment is there, but I am asking, by doing that, how the proceedings, fair trial, evidence, etc., because the person is in a different country, unless you have a diplomatic relationship, you will not be able to. Or there is a common legal framework between two countries where exchange of etc., then there is a possibility. But otherwise, I must tell you, subjective territoriality or objective territoriality is on paper as of now. We need to move much faster and clearer. I think one thing, officer, one thing I want to tell you, for any kind of law and legal enforcement, the geopolitical situation is very, very important. Either you talk about Russia and Ukraine war, or you know, recently in Qatar, Mahindra executive engineer has been arrested. You heard about it? Prior to that, 8 former naval officers were arrested. They were in Qatar, a friendly country to India. Because geopolitical situations really, and in that backdrop, enforcing a law, I think it's very, very difficult. Therefore, we have to wait and watch in what way it can be. Does that mean the people who commit in India, of course they can be subjected. There is no problem at all. I think to that effect, what Professor Nagaratna Madam said and Justice Fanindra also is going to discuss today afternoon, I think they are very, very important if we are in a position to enforce against a person because of subjective territoriality. Yes, please.
May I, with the kind permission of my lord, pose a question?
1 second. Yeah, you carry on.
I'm Nilesh Bhardwaj. I'm currently deputed as principal magistrate. Respected professor, I have one specific question, but it's slightly academic in nature. The question is that in Riley versus California, the Honorable Chief Justice John Roberts propounded a principle saying that if a person is arrested, even if the arrest is legal, even if the person arrested is accused of a very serious crime, nonetheless, if the police wants to search and go through the contents of the mobile phone, the warrant has to be procured from the court, meaning thereby the permission. Then in 2017, we had this famous 9-judge matter privacy judgment, wherein the Honorable Justice Dhananjay Yashwant Chanchur beautifully propounded a 3-pronged test. Then in 2018, we had this slightly, I don't know how to word it, but this particular judgment in a video sexual discrimination case, wherein there was a leak of the video of a rape victim, and the Honorable Apex Court unfortunately refused to lay the law for the reason that there is appropriate guidelines, and we will look into this at a further course of time. So unfortunately, till date, we have not applied the Riley test, and that is not the law as of now. And in all our in the inaugural as well, and in the previous session as well, and in this session as well, we have pondered and discussed upon privacy a lot. So my question is, on the basis of these 3 judgments, that how we safeguard privacy, because there has been a duality and dichotomy between the electronic evidence and the privacy. So that is my question, sir.
Very excellent question. And I'm happy that you gave the backdrop also. I will tell you, I mean, as you yourself mentioned, there is no clarity from the judicial interpretation as of now, even from the Apex Court. I personally feel, indeed it amounts to the violation of privacy. That is my stand. But why they are not able to, I think that is a question to be waited for them to clarify. But otherwise, it definitely tantamounts to violation. That's what I think. Yes, go ahead. Mike. I'm sorry, I think mic not audible.
There's another mic here. You can take this mic.
Now I think it's working.
I think you can come forward. Probably you can come forward.
Hello. We don't have. So exactly, sir. Yeah, but in terms of 2017. Yes.
Sir, my name is Rahul Kumar Kaushik. Sir, this question might appear absurd, but this question comes to my mind, so I asked it. Sir, if a person flee away from his house with his full consent or desire to live alone, by informing his parent via letter or anything, will data protection law come in his protection, come in his rescue to protect his privacy or to prevent tracking of such person on request of his parents?
Yes. First thing, let me clarify, your question is not absurd. You must have guts to ask this kind of question, and you have the gut. Don't worry. Can you repeat once again, loud?
Okay, sir. If a person flee away from his house with his full consent or desire to live alone, by informing his parents via letter or any method, will data protection law come in rescue of his privacy or prevent the tracking of such person on the request of his parents?
Okay. Now, there are two things. What is the age of the person?
18 above.
18 above. You are very intelligent. Second question. DP Act has no relevance. Okay. However, if the person is above 18, he wants to live alone, I think it is a matter of law. I don't think there is any doubt it. Data protection, I don't know, why did you raise that? In what way Data Protection Act is relevant here?
To protect his privacy.
I know, that is true, but you are only worried about if they have tracking, etc., etc. No, definitely not. I am sure they may bona fide interest, they wanted to protect, I mean, you look at as you being, but father and mother look at their son.
Yes, sir, but every person has a soul.
Sure, sure, of course.
And no one tries to control others.
No problem at all. My only thinking is, I hope you are not that person. Don't worry, and I can tell you nothing too. I mean, he asked a very important question. I hope you are aware. Tracking in US, you know for how many people the chip is involved, so that if whenever you move the kind of thing, etc. Nothing to worry. But why don't you look at from their viewpoint?
Yes, sir, but every person, life, this body I get one time. And after that, what happened, I don't know.
But one thing I must tell you, I agree with you. My only thing is, I don't think anybody would disagree with you. But just have a kind of thing for parents as well. That's
I know, sir, but...
I know. You know, you being a judicial officer, everything comes notwithstanding. But it's a good question, it's not absurd. Particular act has no relevance.
But nowadays everybody is having a cell phone, is being tracked by Google.
Yes, but I am sure he will take care. You know, Honorable Justice is saying, if you have a mobile phone, it can be tracked, no? Automatically wherever you go. But plan something else.
I am posing a question to you, which I am facing in the field. It puts the right of accused versus the journalistic freedom. Sir, in Sitamarhi, a circle officer was caught red-handed taking bribe 2 years back. All the media house have covered it. His pictures is everywhere, videos are everywhere. But now, sir, he is constantly mailing the police department, the DM, sir, and every other department for removal of all these videos and news portals and from all print media. So, sir, he is an accused. In our law system, everyone is innocent until proven guilty,
Correct.
and it is still in trial stage. So, sir, this case presents a dichotomy to us, sir. What should we do as law enforcement?
Very interesting question. Let me clarify one thing. The Data Protection Act, journalistic investigators exemption is slightly different. The issue what you have referred is slightly different. I'll put it this way. You said circle officer. Who is that circle officer?
Circle officer is a revenue officer.
Revenue officer. Okay.
He has been caught.
Okay. Now, your question is as police officer, you think the way the person is covered in through different media, etc., and accused is not proven. That is the fundamental. Therefore, how do we balance this? That's what you are asking.
He is asking, revenue officer is asking to remove
every portal. In my opinion, that is not possible. Unless we have either a matter of interpretation or a matter of, till now we don't have that. Only in certain respects we have. For example, a sexual assault, in terms of the victim, the identity shall not be, or the details, etc. But otherwise, unless there is a law, it cannot be. In my opinion, if at all we have a judicial interpretation to that effect, maybe of the concerned High Court, there is a possibility. In Karnataka, speaking for Karnataka, we don't have, because couple of complaints have come in this manner also.
So there is another aspect to it. Now, any offense under the code is an offense in rem. It's an offense against the state.
Yeah.
Therefore, he cannot claim exemption from his photograph being taken out. He does not exercise a right to be forgotten now only, even though he has not been convicted for the offense. So therefore, you're right. It's only with respect to certain class of people who are protected by that right, say a woman or maybe a child or maybe others, but not a person who has been arrested while taking bribe in a trap. Otherwise, it will pose a lot of difficulties so far as the evidence is concerned. The new evidence law, where the photographs, if certified, if kept properly and verified about its correctness, would form proper evidence for framing him. And you see, these days the talk is of even police officers having a camera on their bodies. Camera on the bodies. So if it is with respect to an offense, the offense is against the state totally. So he can't claim any exemption. Whatever he is asking for is useless.
But one thing I am not clear. Where do you stand? With the accused or with the state? That is not clear.
That is a private kind of a thought which he has. Let's not question him.
Honorable Justice came to your rescue. Otherwise, I would not have left you like this. But one thing, even I feel.
No police officer would then ask a question in favor of the right. So therefore, let's not question him. He might be investigating that person.
Yeah. Thank you. Very nice of you.
Thank you, sir. Thank you for this nice forensic eloquence, which was delivered with a lot of forensic skill. Thank you, sir. And we have been offered a kind of a window into what artificial intelligence and what cybercrime would be in the near future. And just to give a perspective, a small one, with Lordship's permission, just 15 days back, we had a case in New York Appellate Court where an a lawyer created by artificial intelligence named Jim, he appeared in the court and actually he started arguing. It was the judge concerned who immediately stopped that. But then this is how we have to face the future. We will have lawyers who is personless, faceless, but then he can argue in the court of law. So with this, we would like to thank my Lord, Honorable Justice Surendra Pandey, Judge Patna High Court, and also Professor S.V. Jogarao for this beautiful presentation and for so lucidly putting the vexed questions of cyberspace and everything with us. Thank you, sir. The Academy expresses its gratitude to both of you, sir. Thank you. And with this, we come to the end of the second technical session. We will meet after an hour in the same place for the third technical session. And for that, we have a small announcement. The honorable judges and our esteemed guest will be having lunch in the VIP mess. And for our deputy SPs, we have arrangement in the cafeteria. And for our judicial officers, we have arrangement made in the mess. So kindly please proceed to your respective places. Thank you so much. We will assemble after an hour for the third session. Thank you so much for your kind attention.
Hello. Hello. Hello.
All the participating dignitaries are again requested to please check their mobile phones to ensure that it is in silent mode. This particular session will be slightly longer session. This will continue for 1.5 hours till 4 p.m. 4:30 p.m. A very good afternoon to all the honorable dignitaries and all the participants who are present here. We welcome you all to the third technical session and the last session, which will have the subject Understanding Electronic Evidence, its collection, preservation, production, and probative value. Now, as far as the title of the subject itself is concerned, this August House is well aware that this will be one of the most useful practical sessions that we have had today. In this session, this will be most useful for the police officers because it will help you in collecting and preserving the electronic evidence for presenting it before the courts. And as far as judicial officers and judges are concerned, this will be useful for you as to how to analyze the electronic evidence, which, as no doubt everybody knows, is going to be, increased in the coming days to come. So I'll make a request to all of you to very kindly and attentively listen to this whole session so that you don't have practical problems in collecting, preserving, and then as far as judicial officers are concerned, in analyzing the electronic evidence when it comes before you, so that cases like Chandrabham, Sadam, Sunab does not take place. Our speakers for this session will be Honorable Mr. Justice Dr. Ansuman, Judge, Patna High Court. An academician par excellence, your lordship has been collectively closely associated with the academics and is a known expert on a vast area of subjects. Our speaker for this session will be Honorable Justice K.N. Fanindra, former Judge, High Court of Karnataka, presently Up Lokayukt, State of Karnataka. We are, sir, honored to welcome Honorable Justice K.N. Fanindra, a distinguished jurist. He began his career as an advocate in the year 1985 and later joined judiciary in 1998 as district judge entry level. He has served in various judicial capacities across Karnataka and has also held the post of Principal Secretary Law and Justice. Justice Fanindra was elevated to the High Court in the year 2013 and superannuated in 2020. Lordship currently serves as Honorable Up Lokayukt of Karnataka and is a noted resource person in judicial education and mediation. May I now humbly request and invite your lordships and the respected speaker on the dais for shedding light on the subject. Please, lordship. I now request Sri Purushottam Mishra, Director, Bihar Judicial Academy, to please felicitate Honorable Mr. Justice Dr. Ansuman. Thank you, Director, sir. I now request Ms. Preeti Anand, Assistant Director, Bihar Judicial Academy, to please felicitate Honorable Mr. Justice K.N. Fanindra. Thank you, Ms. Preeti. I now hand over the dais to Lordship.
Honorable Mr. Justice Ashutosh Kumar, Acting Chief Justice, Patna High Court, come Pattern in Chief, Bihar Judicial Academy. Honorable Mr. Justice Vipul M. Pancholi, JAD 1, Judge and Judge, Patna High Court. Honorable Mr. Justice.
Mic is not on.
Honorable Mr. Justice Pawan Kumar Bhimappa Bejantri, Judge come JAD 2, Patna High Court, come Chairman, Bihar Judicial Academy, all sisters and brother judges of Patna High Court, officials of Registry of Patna High Court, and officers of State Judicial Academy, all participant judicial officers present physically and online mode, all participant police officers present physically and attached online mode in this conference. In the first session and second session, discussion taken place through academic side. We have a discussion has come from the side of the academics that at the time of applicability of the cyber law, you have seen that not only the sections attached and the offences of the cyber law, civil as well as the criminal, rather the BNS, the POXO, and the other offences, how it be attached. In the second session, we have seen, and discussion takes place by Professor Jogarao, now practicing, that what is the jurisdictional aspect of the matter, the liabilities, and the other things which are attached, but all those points in the first and second session was the academic one. This session is the most vibrating and the practical aspect of the matter. Brother Fanendra have well experienced person and extremely popular faculty, having experience of visiting in the different judicial academies and of academic bent upon, having practical experience. I am hand over to mic to him so that without losing any time, he may share his experience on this practical aspect of the matter. Brother.
Good afternoon to all. Honorable Acting Chief Justice of Bihar High Court, Justice Ashutosh Kumar, and all the companion judges of Bihar High Court, and particularly the participants from various departments including Judiciary and all other stakeholders so far as this electronic evidence is concerned. Before starting, I was so impressed by the speech of Honorable Chief Justice. I want to start my deliberations with a short story. So how we have to participate in such conclaves, it can be very well understood by this story. You all heard the name of King Akbar. Birbal was one of the intelligent ministers in the court of Akbar. Once a saint or a philosopher came to his court with 3 dolls. All the 3 dolls were similar. There was absolutely no difference between the 3. They were not like Gandhiji's 3 dolls, where one was shutting its eyes, another was shutting his ears, and another was shutting his mouth. That is simple. It gives a message to the society that don't look at the bad things, don't hear bad things, and don't speak bad things. But anybody can imagine that message passing through those dolls. But these 3 dolls were so similar, nobody could identify what message that will pass on to the society. Almost all the ministers in the Akbar's court failed in answering the question of that philosopher that what message those dolls were giving. But Birbal was so intelligent, he took 1 day time and requested that man to give that doll to him to keep himself for 1 day. He went to his house along with the dolls, and even throughout the night he could not be able to ascertain. He could not be able to catch what message those dolls were giving to the society. Ultimately, he was also thinking that I will also fail in the court. Just he wanted to go to the court of Akbar. He saw his daughter was playing with those dolls. She was putting a nylon thread through one ear of that doll. It came out from another ear. So he got the point. He got the message of all the dolls. He came to the Akbar's court. He said that this is first doll where the thread was passed through 1 year and it went out or came out from another year. And he said that one category of people, they will go everywhere, they will sit everywhere, and they will hear everything, they will see everything. They will not take that into their head. They will simply take from 1 year and leave it out from another year. They are not only not helpful to themselves, but not helpful to any others or even to the society. He put the thread into the ear of another doll. It did not come out at all. Then he said, so these are the persons, though they may not be harmful to the society, but they are not helpful to the society. They will receive everything. They will see everything. They will understand everything. They will take that into their head. And they will put their contribution also to that. And they will utilize for their benefit only. They are selfish. The lost doll to which the thread was thrown or passed through 1 year, it came out from the mouth. Chief Justice has said in the morning that all of you have collect the materials from this type of conclave and speak it out through your mouth, spread it out through your mouth to all your friends. That is what the third doll is telling. That he said that they receive the light from every source. The people receive the light from every source, that is light of knowledge from every source. They will put their contribution into it and they will spread that knowledge to the society. So therefore, I want all of you to become third dolls. So with this prelude, I would like to start these deliberations on this subject matter. So before adverting to the electronic evidence as such, or electronic materials or gadgets, form or whatever you call, we have to understand what is the duty of the court, whether it is an electronic evidence or any other evidence before the court. So it is an adjudicatory body. The courts are adjudicatory bodies. They have to ascertain the facts first and who are all the parties at variance, and then ascertain what exactly the parties dispute before the court of law, whether it is a criminal case or it is a civil case. Then find out that what is to be proved before the court by them. And next is how it is to be proved. And last one is who has to prove that, in what manner. So in what manner only we are strongly concerned here. In what manner, what is the evidence to be proved before the court and how it is to be proved before the court. So for this, Section 3 will help us which say the fact and fact in issue and as well as a relevant fact. These two things play a very, very important role. The judges have to understand what is meant by a relevant fact and what is meant by a fact in issue, whether it is a criminal case or in a civil case. What is meant by fact in issue and then relevant fact. The fact in issue is nothing but what has to be adjudicated by the court on the basis of the pleadings of the parties. That is, you formulate issues so far as civil cases are concerned, which are mainly connected to substantive law, not procedural law. Substantive law means which gives rights, liabilities and disabilities. Only these three things. So once the right is created by any statute, whether under the Information Technology Act or under any law for the time being in force, a right is created. Once the right is created, remedy must be there to that right. That is what we say, ubi jus ibi remedium. And thereafter, you have to respect the right. He will approach the court and consequently a liability is fixed on the other side. So rights and liabilities we have to adjudicate before the court of law. adjudication of rights, liabilities on the basis of facts using the substantive law, you frame the issues, you have to answer those issues in civil cases. Like that way, you frame charges in the criminal cases, which are again based on substantive laws. So once these things are crystallized by means of framing specific charges and specific issues in criminal case, then question arises the relevant facts and the connection between one relevant fact and another relevant fact, and in turn the connection between the fact in issue. So there may be innumerable number of facts in issue, innumerable number of relevant facts. So every fact, relevant fact which comes before the court in any manner, it may come in any manner because section 3-50 of BNS explained the relevant facts. Some relevant facts may also come which falls out of these provisions under section 3-50. Then what the court has to do? Because the law says that the relevant facts are already explained under section 3-50, you cannot use any other relevant fact as per your whims and fancies, as per the whims and fancies of the judges. Because of the reason, there are so many relevant facts which are not admissible in evidence at all. For example, Indian Evidence Act, recovery of weapons or any other materials at the instance of the accused on the basis of discovery of fact. The statement made by the accused, though it appears to be relevant, but the whole statement is not admissible in evidence. Only to the portion with reference to the discovery of a fact is admissible, not other things which he admits the guilt. The confession made before the police is not at all admissible. So therefore we have to understand these relevant facts may be by way of any other material and also by means of electronic materials before the court or electronic evidence before the court. So therefore those also becomes relevant. Because of that reason, so many amendments have been brought in to the BNS and also consequently to other major procedural provisions, that is BNS, BNSS, BS, and then the Indian Penal Code, that is Bharatiya Nyaya Samhita. So therefore we have to understand the concept of this electronic evidence on the basis of this connectivity between the substantive law and as well as the procedural laws. So the main object of the concept of electronic evidence by bringing amendments to the various laws for the time being in force, in order to treat equally the old method of maintaining records and new sophisticated maintaining of electronic records. The same fact, a relevant fact, which we were dealing with earlier, we have to deal with the same set of facts in different manner in the electronic evidence field. For example, sale deed was being on the stamp paper, executed by the parties, executant and witnesses, etc., registered before the sub-registrar, and then copies were given on the basis of typewriter or handwritten copies. Now the same thing is completely replaced by means of electronic method. The signature need not be there. Physical signature need not be there. It can be digitally signed. The document can be digitally signed. So the methodology with regard to the admission of a particular document or evidence, whether it is oral or it is documentary, the methodology is changed now by virtue of the introduction of this electronic evidence. So therefore, the maintaining and producing the records, first is maintaining of the records in an electronic manner or electronic method, and production of those documents before the court. So as you all know that mere production of a document is no proof, or it is no evidence before the court, unless it is admitted in evidence in accordance with law. That is what we said earlier, what we were dealing with the documents earlier, we have to deal with similar documents in a new methodology. In a new vision, we have to look into it. So it is just like production in electronic records in electronic form, that is digital information, data, etc. before the court of law, which includes the documents, emails, messages, multimedia, files, computer data, network data, etc., etc. These were not there earlier. So earlier what we were having is now completely replaced by this, or we are replacing. A day may come in future that completely it will replace the earlier methodology. So therefore, that is the concept of electronic evidence. In order to give equal treatment, merely because it is an electronic evidence, you cannot say that it is not admissible, subject to the condition that some procedural aspects have to be followed. The next concept under this electronic evidence is to give importance to the rights acquired by various substantive laws. So IT Act came into force in the year 2000. So lot of rights have been acquired by the people under that IT Act. Various offences have been classified under the Information Technology Act. So whether it is criminal or civil, whatever it may be, we have to give importance to the rights which are acquired under the various provisions of substantive laws, including the Information Technology Act. So for that, the third important aspect is that for the purpose of giving importance to these electronic evidence before the court of law, we must have sufficient and adequate laws. For that, we have brought so many amendments to the Indian Evidence Act, rather now BNS, Bharatiya Sakshya Adhiniyam. Though it is named differently, but even earlier to that, when it was called as Indian Evidence Act, the amendments were already bad. It was under 65A, B, and so many presumptions, etc., etc. So therefore, the concept of this electronic evidence now crystallizes in order to bring the electronic evidence before the court of law, how it should be preserved, how it should be collected, how it should be produced before the court, and how it should be preserved during the course of trial till the case is logically ended. So to that extent, we are concentrating on this particular aspect. So next, there are classifications of this electronic evidence. Classification means that in what manner the electronic evidence is available to us. How we can receive the electronic evidence. In what form? So that it is classified that digital or electronic documents in electronic form. Electronic documents, electronic record, which is a data which is available inside a particular electronic form. It may be a compact disk, We don't know what the compact disk contains. The contents of that compact disk, it may contain a document, it may contain a videograph, it may contain a photograph. So therefore, the digital or electronic documents in electronic form is the first classification. Either it should be a document inside that form, in what form, what nature it is transmitted to that particular electronic gadget or to the computer. The next is multimedia. Apart from the computer, we have so many other multimedias. Any document, any picture, video, audio clipping, etc., metadata, every information which is available with regard to that format is another classification. We have to analyze that also. The computer created or generated records. We will go in detail so far as when we deal with section 57 and 63 is concerned. So created documents in the computer, because everybody is innovative nowadays. They will innovate so many things on their computers. Once it is created or it is innovated on his computer, that becomes the original in the computer. So originality has to be tested, whether it is created or whether it is generated automatically on the basis of something is fed to the computer. 2 plus 2, it will calculate, it will give 4. We will not type 4 there. It automatically generates the number 4. Like that way. Next is communications. For example, every electronic gadget is used for the purpose of either creating or generating, transmitting, transmitting. So that is, we make communications on the basis of this electronic format, methods. So other electronic records that, as I already told you, metadata, and then digital signature, certificates, data from other devices, transmission, etc., etc. So these are all the classification if we see this. So something we were earlier doing by means of crude method of, for example, if you want to communicate something to others, earlier method was writing letters. Writing inland letters if you want to say something confidential in a closed cover. So that is now it is completely transformed into an electronic evidence. If you want to say something, if you want to say some information to others, we will send it protected with a password. So that is envelope, closed envelope, now protected with a password. Nobody can enter into unless you give the public key to that man. Private, you operate your private key and lock it, giving a password to him. That is, the password is the public key to him. He will open it. So the exclusiveness is maintained here also, but in a different methodology. So in this context, we have to understand what is evidence and its purpose. So there are so many amendments that have been brought into BSA. The evidence, what is the evidence now? All statements, including statements given electronically, which the court permits or requires to be made before it. The two things are here. Court permits or requires. The court permits means it involves the procedural aspects to be followed. Is there any condition precedent to be followed before court admitting that, accepting that evidence before the court? then only the court will permit that document to be placed before the court for the purpose of marking or for the purpose of reading it as evidence later. Court requires, the discretion is given to the court even though the party has not produced anything. If the court feels that it is absolutely necessary for proper and rightful adjudication of the rights of the parties, then it can call anybody to give evidence. It can call anybody to produce any document, that is including the electronic evidence. So what we have to understand is that we can call for any evidence before the court, you can permit any evidence before the court, but it should be legally admissible. Such evidence can be placed before the court. So document is all documents including electronic or digital records. The first one is with reference to the oral evidence. The second one is with reference to the documentary evidence produced for the inspection of the court. See, the words used there and here are two different. There it says that court permits require. Here it says for the perusal of the court, or it is for the inspection of the court. Documents. Why it is said the court has to inspect the documents, for what purpose? We have to understand that. Whether it is an electronic evidence or any other evidence for the time being in force. If it is electronic evidence, it is produced before the court. Mere production, as I have told you, is no evidence before the court. Suppose if the document is produced before the court, a CD is produced, a pen drive is produced. When it is produced, if it was empty, what the court has to do? Whether production also can be allowed? Answer is no. If simply some white papers have been produced before the court, can the court allow it? Simply shutting its eyes? Definitely the answer is no. Or else, if voluminous documents have been produced, though they are not relevant, can the court shut its eyes and allow the parties to produce those voluminous documents which are not at all necessary for the adjudication of the case at all, no, not at all relevant? So therefore, in order to test these important aspects, it is said that it should be produced for the inspection of the court. After inspecting, you can permit for production of the electronic evidence, and then after ascertaining the relevancy of that particular fact, and after the condition precedents have been followed, then you can permit to admit those documents before the court. So what is document so far as the electronic evidence is concerned, or digital records are concerned? So it is any matter expressed or described or otherwise recorded upon a substance by means of figures, marks, or any other means, or by more than one of these means, intended to be used for the purpose of recording that matter and including electronic digital record. The paper and pen is there, I write something and put my signature. The same thing, I type it on the computer and I put my digital signature, or even I will not do anything, but I will prepare something on the computer and take the printout. So here, two things. One is, I have written it on paper, but I have done the same thing on the computer and taken a copy on a flappy or a disk, whatever you call it as. Is there any difference between the two? Now, the only difference is, this is electronic record, which is a data. Either I want to create it, whether I want to store it, whether I want to transmit it to some other person, forward it to some other person, whatever may be the result, I have done something on some object. So if it is done in the manner recognized under the Information Technology Act, that also becomes a document. Therefore, we have to, for example, writing, painting, lithography, photography, map, plan, inscriptions, caricature, email, everything, all those things, whatever may be the nature of the inscription or writings, if it is by way of electronic means, electronic method, then that will become a document. So now comes what is the electronic record as explained in Information Technology Act. Electronic record, there is some difference between electronic record and form. Though the definition appears to be similar, but there is a slight distinction between the two. We have to understand that data record or data generated, image or sound stored, received or sent in an electronic form, or microfilm or computer generated microfiche. That is, there should be some record inside that particular object. As I told you that a disk is there, fiche is there, and pen drive is there. If it is empty, there is no information at all. So whatever the information you feed to the computer or to any of the other electronic gadgets or whatever you call it as, multimedia, that will form, it is in the form of a disk, it is in the form of a pen drive which contains some information. So record means the information inside that particular document or inside that particular electronic format, and the form in which form it is there, that is what we call it as electronic form. That is explained in section 2(1)(r) of the IT Act. So having analyzed this, we have to understand the application and definitions given in the other acts. Section 2(2) is very important so far as the judicial officers are concerned. You see, as I told you that lot of amendments have been brought into these three important major enactments. So there is no definition given in Indian Evidence Act or the BSA, but the same definition is given either in Criminal Procedure Code, BNSS, or in the Indian Penal Code, BNS, or under the Information Technology Act. So this is the interconnection between all the three enactments so as to harmoniously understand what is the intention of the legislators. The intention of the legislators is that if the definition is given in some other law, particularly it says that three laws. One is BNSS and BNS and BSA. In any of the three important enactments, if any definition is given, if it is not there in other enactment, so that has to be understood in such manner. That definition has to be adapted. That means to say that you cannot go to General Clauses Act or you cannot go to a dictionary for the purpose of ascertaining the meaning of that word or a phrase. So that you have to understand that it harmonizes almost all the three enactments. As it is very good example, as I've already taken you through, electronic record, electronic form, computer system, computer network, computer resource, communication device, etc., which has been specifically defined under the Information Technology Act. But those definitions we don't find in BSA, but we find those words, we find those phrases. So apart from this, Section 4 and 5 are very important, which are given legal recognition of the electronic records. Suppose, as I told you, if something has to be earlier, something has to be written on a paper. That is, we have taken the definition of document. Something is there on some object. So earlier, for example, if you want to execute a sale deed, you have to prepare the sale deed and parties have to put their signature, and then it should be produced before the sub-registrar and he has to examine and he has to put his signature, etc. That process was there. So if the same thing is done, if something is to be written on the paper, if the same thing is done by means of electronic method, that legal recognition is given to that particular electronic methodology, electronic evidence is concerned. It is made available in the electronic form. And the electronic signature, same, Section 5 says that with regard to electronic signatures. So earlier, physically we were putting our signatures. Now, signatures are not visible. If it is an electronic signature, signatures are not actually visible. It is invisible, though we say that the document is electronically signed. So these are all the two important aspects we have to understand before going to the oral evidence, documentary evidence primary and secondary. There are three types of evidence. One is oral evidence, another is documentary evidence, and third one is real evidence or material evidence. What is it, real evidence or material evidence? Apart from this oral and documentary, we say in a criminal case some object is recovered. Some materials have been produced before the court. In Copyrights and Trademarks Act, normally they produce the object itself before the court for the purpose of comparison, whether it violates any copyright or trademark or like so. So that object itself is produced before the court. Like that way, if any object is there, either in criminal law or civil law, that object we call them as real evidence or material evidence before the court. The next is subclass is circumstantial evidence. Almost all in electronic evidence cases, I will tell you, the circumstances play very dominant role. Earlier, Section 114 of the Indian Evidence Act, now it is amended. It gives some guidance as to how we have to treat a particular circumstance, how we have to draw an inference on the basis of such circumstances. So next is hearsay evidence, as all of you know. The hearsay evidence, it is recorded on the basis of an electronic method. Somebody has given some opinion that is recorded in your mobile, and you want to produce that before the court. So what is hearsay? Means it is not direct. It is received some other source and he translated that or repeated that same thing by somebody. So he almost act like an intermediary which we technically call under the Information Technology Act. Intermediary means he gets something from somewhere else and he will transmit it to all, that we also receive it. So this evidence, oral evidence and documentary evidence, when oral evidence with regard to the electronic evidence is admissible, the contents of, because BSA says that oral evidence is not admissible when documents are produced before the court. The contents of an electronic record, whether it can be adversely spoken by the parties once the document itself is produced before the court. Only if there is any contemporaneous document, then only the parties will be allowed under Section 90 onwards, earlier Indian Evidence Act. Under what circumstances court has got discretion to allow the parties to give evidence even on the contents of a document. The intention was not clear, the document is ambiguous, to explain all these things. So like that way, if the electronic document is produced before the court, oral evidence is to be excluded. So far as that aspect is concerned, that document is concerned, content is concerned, unless the genuineness of the electronic document itself is in dispute. So therefore, on the basis of this, we have to consider the oral evidence, oral admissions, and there are several amendments to the BSA, etc. So if in a civil case or in a criminal case, if a document is produced, just like an entry is in the books of account, so the regularity of the transaction we have to see under Section 28 of BSA. Like that way, under Section 29 BSA, electronic record made in performance of the duty. So we don't know whether every office is having electronic computers or they have facility of recording the digital records, etc., etc.
Dear participant, for the purpose of proper understanding of my brother, I just interrupt for 5 minutes and I just want to explain from a different angle, because my brother is dealing with the electronic evidence and digital evidence from legal angle. Since I belongs to a student of physics, my paper is electronics special. So for the purpose of proper understanding of the subject which my brother is explaining to you here, I just want to explain you what is the basic distinction between the electronic evidence and the digital evidence. Actually, this concept has come in the Indian Evidence Act considering the document. And for the purpose of proving this concept has developed, I just want to discuss you with the technology that how the evidence used to be preserved. Initially, by virtue of writing, evidence used to be preserved. The recording, tape recorder we can say digital recorder, we can say fetching. So these are the technologies. And in all technologies, responsibility of the movement of the electron is responsible. हम सब लोग टेप सुनते रहते थे, टेप पर हम लोग गाना सुनते थे. The methodology of recording is कि माइक पर हमने गाया, वाइब्रेशन हुआ, इलेक्ट्रॉन का मूवमेंट हुआ, और ये हम सभी जानते हैं, 8वां में हम लोग पढ़े हुए हैं कि इलेक्ट्रॉन इन मोशन क्रिएट्स मैग्नेटिज्म. एंड एक टेप पर हम फेरस मटेरियल लगाते हैं, बिकॉज मैग्नेटिक मटेरियल फेरस मैग्नेटिक मटेरियल है. तो जैसे ही वहां वाइब्रेशन होगा, मैग्नेटिक फील्ड चेंज होता है, वहां पर टेपिंग और स्क्रैचिंग हो जाती है. तो दिस इज द टेक्नोलॉजी विच इज बीइंग डेवलप्ड for the purpose of recording on magnetic tape. सब्सिक्वेंटली डिस्क पे भी वही टेक्नोलॉजी थी कि वाइब्रेशन हुआ और एक बड़ा नुकीला माध्यम वहां हम डिस्क पे रखते थे, उसमें वाइब्रेशन आती थी, वो डिस्क पे स्क्रैच कर देता था। तो इस तरह से बाय वर्च्यू ऑफ मूवमेंट ऑफ इलेक्ट्रॉन हम टेप की स्क्रैचिंग करने लगे, हम डिस्क पर स्क्रैचिंग करने लगे, हम मैग्नेटिक टेप पर स्क्रैचिंग करने लगे, लेकिन रिस्पॉन्सिबिलिटी यही थी कि वो सारे के सारे इलेक्ट्रॉन के मूवमेंट की वजह से हो रहे थे। साइंस ने फिर तरक्की कर ली। तो हम जानते हैं कि शुरू में बड़ा गाना ग्रामोफोन, बहुत से लोगों ने देखा है, ग्रामोफोन पे हम निडल रखते थे, जो वाइब्रेशन होता था उसकी स्क्रैचिंग होती थी और वो साउंड रीजनरेट होता था यदि हम सुई उस पर रखते थे। साइंस ने जब फर्दर टेक्नोलॉजी बनाई तो इन लोगों ने और नुकीला निकाला और टंगस्टन का यूज होने लगा, उससे और कम स्पेस में। इनिशियली इतने बड़े स्पेस में 5 मिनट का गाना रिकॉर्ड होता था, इतने ही बड़े स्पेस में 90 मिनट का गाना रिकॉर्ड होने लगा। और साइंस ने जब तरक्की की तो लेजर बीम का आविष्कार हुआ और लेजर बीम स्क्रैच करने लगा, उसको हम लाइट स्क्रैचिंग कहते हैं। लेजर बीम बहुत ही आसान मेथोडोलॉजी है लाइट के डेवलपमेंट का, कि हम सभी जानते हैं कि इलेक्ट्रॉन्स एटम के आउटर मोस्ट ऑर्बिट में रन करता है और प्रोटॉन न्यूट्रॉन इनर ऑर्बिट में रहता है। इलेक्ट्रॉन के कई ऑर्बिट हैं, के एल एम एन ओ पी, जो साइंस के विद्यार्थी 8वां 9वां में हम सबों ने पढ़ा है। जैसे ही इलेक्ट्रॉन हायर ऑर्बिट से लोअर ऑर्बिट में जंपिंग करता है तो एनर्जी का इमिशन होता है और वो लाइट के रूप में निकलता है। बस आते हैं सर।
I am not on technical side at all.
नहीं सर, उस पे आ रहे हैं 2 मिनट।
I am only on legal side, sir.
मैं उस पे आ रहा हूं सर, मैं उसी को जस्ट आपको हैंडओवर कर रहा हूं, मुझे 15 मिनट को समय दे दीजिए। माइक हैंडओवर। I will on 15.
I want to make it clear, I am not a technical man.
नो सर, मैं जस्ट 15 मिनट में आपको माइक हैंडओवर कर रहा हूं। तो ये टेक्नोलॉजी जब डेवलप की तो जो वो लेजर बीम थी, लेजर बीम से स्क्रैचिंग होने लगी और 3 घंटे 4 घंटे की लेजर बीम थी। अब ये है कि ये हमारा जो पहला टॉपिक था, कंसेप्ट ऑफ इलेक्ट्रॉनिक एंड डिजिटल एविडेंस, उसका बुनियादी कंसेप्ट यही है कि फ्रॉम द लीगल पॉइंट ऑफ व्यू इलेक्ट्रॉनिक और डिजिटल एविडेंस दोनों ही बेसिकली इलेक्ट्रॉनिक एविडेंस ही हैं और दोनों के लिए रिस्पॉन्सिबल इलेक्ट्रॉन ही है। अब ये प्रश्न है कि जब हम साइबर मोड में हम काम कर रहे हैं और इंफॉर्मेशन टेक्नोलॉजी में हम काम कर रहे हैं तो लॉ के हिसाब से, अकॉर्डिंग टू लॉ, हम सेंडिंग ऑफ सर्विस, रिसीविंग ऑफ सर्विस, एक्नॉलेजमेंट बाय द कोर्ट, ये टेक्नोलॉजी है। ये टेक्नोलॉजी डिस्कशन के लिए सेक्शन 11 से सेक्शन 13 ऑफ द इंफॉर्मेशन टेक्नोलॉजी एक्ट वेरी क्लियर। इन्होंने सेंडिंग वर्ल्ड के लिए एक शब्द इस्तेमाल किया, एट्रीब्यूशन। इंफॉर्मेशन टेक्नोलॉजी एक्ट ने एट्रीब्यूशन नाम का एक शब्द इस्तेमाल किया और एट्रीब्यूशन का मतलब ये डिजाइन करते हैं कि द पर्सन हु हैज जनरेटेड द मटेरियल, चाहे वो इलेक्ट्रॉनिक एविडेंस जनरेट करे या साइबर जनरेट करे, वो अपने पास से सेंड करेंगे और सेंड के बाद एक्नॉलेजमेंट होगा दूसरे सिस्टम में, और जब एक्नॉलेजमेंट की रिसीविंग आएगी तभी उसे सर्विस माना जाएगा। यह सेक्शन 11 से 13 में किया गया है। आज के डेट में हम लोग स्पेशली इस प्रोग्राम को अरेंज इसलिए किए हैं कि हम लोग इंफॉर्मेशन टेक्नोलॉजी, डिजिटल पर्सनल डाटा प्रोटेक्शन और जो इनिशियल 2 क्लास में हम लोगों ने एकेडमिकली डिस्कस किया कि कैसे साइबर लॉ के रॉन्ग्स में बीएनएस के सेक्शंस ऐड होंगे, उसकी इन्वेस्टिगेशन होगी, उसके ट्रायल होंगे, उसकी इंक्वायरी होगी, और फ्रॉम द एंगल ऑफ जुडिशियल ऑफिसर्स, फ्रॉम द एंगल ऑफ पुलिस अफसर, फ्रॉम द एंगल ऑफ विटनेसेस, कैसे उन डॉक्यूमेंट्स को हम प्रोड्यूस कर पाएंगे। बेसिकली हम लोग यहां इसके लिए बैठे हैं, जो सर डिस्कस कर रहे हैं, सर उस बात को डिस्कस कर रहे हैं सेक्शन वाइज। मैं ये कहना चाहता हूं कि उस एविडेंसरी वैल्यू को लाने के लिए जो इंफॉर्मेशन टेक्नोलॉजी ने और बीएनएस ने जो बात कही है, उसमें 3 बातें बड़ी इंपॉर्टेंट हैं। बीएनएस के डिफिनीशन सेक्शन में और बीएनएस के सेक्शन 530 में ये स्पष्ट रूप से इंटर हो चुका है कि फॉर द पर्पस ऑफ कंडक्टिंग इंक्वायरी, इन्वेस्टिगेशन, ट्रायल इलेक्ट्रॉनिक मीन इस्तेमाल होगा और इंफॉर्मेशन टेक्नोलॉजी का यूज होगा। इंफॉर्मेशन टेक्नोलॉजी के यूज के लिए एक बहुत ही इंपॉर्टेंट बात है कि कंप्यूटर बेस्ड डाटा जितने भी क्रिएट होते हैं वो साइबर स्पेस में क्रिएट होते हैं, और साइबर स्पेस हमारे ह्यूमन माइंड के लिए इनडिस्टिंग्विशेबल है। कोई भी ह्यूमन माइंड साइबर स्पेस में नहीं काम कर सकता। तो उसके लिए जो एक्सपर्ट्स हैं उन्होंने जो एडवाइस किया कि अगर साइबर स्पेस को हम देख नहीं सकते तो ह्यूमन माइंड के द्वारा परसिबल भी नहीं, वो परसीव नहीं कर सकता, तो साइबर स्पेस को अंडरस्टैंड करने के लिए इन्वेस्टिगेटर को देखना है, साइबर स्पेस समझना है, कोर्ट को समझना है, दोनों साइड के एडवोकेट को साइबर स्पेस समझना है। उसके लिए वो कहते हैं कि आप 3 लाइन फार्मूला याद रखें। कंप्यूटर इज द टूल, कंप्यूटर इज द टारगेट एंड कंप्यूटर इज द इंटरमीडियरी। जो कंप्यूटर साइबर रॉन्ग को करने के इस्तेमाल हुआ वो रॉन्ग डूअर है, उसको पनिशमेंट होगा, ट्रायल उसका होगा। जो कंप्यूटर इस्तेमाल हुआ है टारगेट के रूप में, दे आर विक्टिम, उनको जो कंपनसेशन स्कीम है या सिविल की जो स्कीम है वो मिलेगी। और जो कंप्यूटर इंटरमीडियरी है, जिसकी चर्चा सेकेंड क्लास में की गई थी इंटरमीडियरी की, उस इंटरमीडियरी का कंसेप्ट जो जोगा साहब ने बताया कि 2009 के पहले और 2009 के बाद सेक्शन 79 ऑफ द साइबर टेक्नोलॉजी एक्ट में उसके इस्तेमाल की चर्चा ये की गई कि इंटरमीडियरी को बेनिफिट दिए गए। लेकिन 2009 के बाद जो अमेंडमेंट आए हैं साइबर टेक्नोलॉजी 2009 में, वो उस एग्जम्पशन को विद कंडीशन के साथ एप्लीकेबल किया है। तो मैं अपनी बात को यहां कह के कंक्लूड करके माइक हैंडओवर करता हूं ब्रदर को, कि जो बातें ब्रदर बता रहे हैं वो बेसिकली बुनियादी बात बता रहे हैं, जिसको आपको ध्यान से ये समझना होगा कि जब साइबर एविडेंस, चाहे वो इलेक्ट्रॉनिक मीन्स से हो या वो डिजिटल मीन्स से हो, जब वो कोर्ट में प्रोड्यूस किया जाएगा तो किन किन प्रिंसिपल्स को फॉलो करना है उस पर चर्चा हो रही है। इसलिए इसको ध्यान देते हुए उसको सुने। मैं उस ब्रदर को माइंड कॉल करता हूं जी।
Thank you, sir. As I told you that I am not a technical man and I don't know the meticulous technology of these electronic gadgets and other things. But what the court has to do, court has to understand, court has to analyze when an electronic document is produced before the court, how the electronic evidence is recorded, how it is transmitted. All those things I am not concerned to say all those things about, because only a technical man can say all those things. I can only say if the electronic document is produced before the court, what the court has to do and how the police officers at the time of investigating the matter collect the information or collect the electronic materials or electronic evidence, and how they have to preserve and how they have to produce before the court. So only on that point I am to concentrate, and it is also there in the subject allotted to me. So now we shall pass on to the how to preserve the electronic gadgets by the police officers. The preservation of electronic documents is very important role. It is better the police officers know that during the course of investigation, the collection of electronic evidence from different areas, including the spot. So once they collect it, how they preserve is the next question, again a technical point. In what manner they have to protect, in what manner they have to preserve, because it passes through the hands, various hands, till it reaches the court. And even after it reaches the court, it will have its own procedure to be followed for the purpose of admitting it. And then even at the time of appeal, it should be preserved till the case is logically concluded. So here, Suppose the police officer voluntarily seizes an article or recovers the same from the accused or any other person during the course of the investigation. First they have to do is that, not technically, but they have to seize the entire system, the computer, if it is available, or any other electronic evidence on the spot. So for the purpose of to see that the information inside that particular document is not lost, they have to take utmost care in order to preserve that and protect that till the same is produced before the court. So the preservation and the protection is altogether different. Suppose if the seizure is made, seizure is different from recovery. So seizure is made, recovery is made. The police officers have to keep it in a particular Faraday bag or any other protective measures they have to take. That totally the object is to see that the contents of that particular computer or any other electronic goods, the content or the information is not lost. So thereafter they have to analyze the contents of the same by putting the same into their computer. So again here the second protection starts. Once you analyze that and thereafter you will transfer it to some other multimedia by means of optical objects, that also to be protected, that also to be preserved in a proper manner. So because the object is transferable, once you put it into the computer output will come. So after the computer output, you will transfer the same to some other examiner or a forensic lab and whatever you call it as. So therefore it goes somewhere else and come back to you. So till that point of time, it should be preserved and protected. So therefore, the police officers who are here, they have to take utmost care for the purpose of protecting them in an anti-static cover, bubble wrap, variety bag, jewelry box, whatever it may be, you call it as, in a proper manner. So then you have to take care of custody of the documents. So what is meant by custody? The person who is having possession of an electronic record, he will be called as the custodian. Whether that custody is recognized under law or not is to be looked into. So what is meant by proper custody? It is explained in the Information Technology Act and also under the BSA. The custody should be ascertained that the proper custody, legal custody are altogether different versions. I may have a mobile, I am the employer, I have purchased this mobile and gave it to my employee for the purpose of user. So he uses continuously for the purpose of official use and also for various other purposes. So the custody, I am the owner, I am the legal owner of that document, electronic gadget. But on the other hand, the other person is also having proper custody of the same. So like this way, wherever this document goes, suppose you send for forensic examination, the CD, DVD, DVR, whatever you may call during the course of investigation you seized or recovered, you send it to the examiner or forensic examination. So the custody passes from you to that man. And after analysis, he will send it back to you. And thereafter, you make a copies of that and you produce them before the court of law. The court becomes the custodian of that document thereafter. And one copy under section 207 of CRPC will be given to the accused or the other party. So then to that extent, the copy which has been furnished to him, he will become the proper custodian of that particular document. So therefore, if the document passes through, the electronic record passes through hand to hand, and ultimately it comes to the court. Till that point of time, we say that who is the proper custodian of that particular electronic document. So the court has to analyze this particular aspect by applying the guiding principles that where they would naturally be kept, under the care of the person with whom they would logically be entrusted. It essentially means the documents are in the correct place or with the right person. These are the guidelines the court has to analyze before accepting whether it produced from the proper custody. So the chain of custody, again, as I have told you, if it passes through one hand to another hand, till it comes back to the court, till that point of time, if various hands are changed, every stage, the chain of custody continues, proper custody continues. So this has to be taken care of by the police officers and the judicial officers to see that the chain of custody is proper and complete. The important aspect we have to look into is that with regard to the preservation of this electronic goods. I will give you one instance. When I was a sitting judge of High Court of Karnataka, one CD was produced in a criminal case in the appellate jurisdiction. It was produced before the trial court, and thereafter the accused was convicted only on the basis of a strong circumstance of recovery of jewelleries belonging to the deceased. The record was sent to the appellate court, even stitching the compact disc. It was stitched. And when we were hearing the appeal, we removed that stitch and tried to play that. The stitch was at the end of the disc, therefore, what once or twice it played. We witnessed what was there, the contents of the disc, where the trial judge has not done that at all. So the recovery of a jewellery at the instance of the accused, which was not earlier known to anybody, was the case of the prosecution. If the judge would have seen that, he would have acquitted the accused, because by the time the police and the accused reached that spot, so many people were gathered, and some people have brought that, put it into the hands of the accused. Thereafter, it was recovered at the instance of the accused. So here, why I want to say is that even the courts are committing some mistakes preserving this electronic material which is already placed before the court. So therefore, I have laid down some 10 guidelines in that particular judgment in Madhukar alias Madhu alias Mallesh versus State of Karnataka in criminal appeal number 615/2013. So therefore, without deliberating much on this particular aspect, the chain of custody should be complete, and protection of the electronic materials should be taken care of, and preservation of the electronic material till the case is logically ended is to be taken care of. Next is production of the electronic documents before the court. What the court has to do, if the document is produced, whether it is obligatory on the part to produce all the certificates along with the documents, electronic documents. So the production, once it is produced before the court, in my personal opinion, the court has to examine before taking that record on to the court record. As I told you that sometimes it may happen, a pen drive or a compact disc or any multimedia is produced before the court, which may be empty. It may not contain any information at all. So what is the necessity of permitting the party to produce such documents before the court. Therefore, initial stages when it is produced, the court can check it up with their CMOs or Shirastisars, whatever you call it here, in order to ascertain whether it complies the requirement of a document. If it is a document, then only you can. Document means, record means, electronic record means it should contain some information inside. If there is no information at all, the production is not permissible. Therefore, the word used there is court permits. So if suppose along with the documents, the certificate is produced, okay, it is well and good, it can be taken on record. If suppose at the time of admitting the document before the court, the certificate under section 63 is an absolute requirement. So for that we will cover the particular aspect when this particular certificate has to be produced before the court and how the certificate should be while dealing with section 63. So when it becomes impossibility to produce the document, what the court has to do, that also we will discuss little later. So once the document is produced before the court, it becomes the duty of the court or the parties who produce those documents, whether it is a primary document or whether it is a secondary document. So primary documents are those which can be directly produced before the court, and like any other document, electronic record also can be produced which is contained in an electronic gadget. For example, mobile, it contains video, audio, photo, etc. If the mobile itself is produced before the court, that becomes a primary evidence. So in order to ascertain this, section 57 has undergone some amendment. So explanation 1 to 3 is referable, applicable to the primary evidence otherwise than electronic record. So far as section subclass 4, explanation 4, 5, 6 and 7, they are concerned with the electronic record. So what is primary has to be understood. What is primary record has to be understood only applying the principles which are laid down in this particular provision and not otherwise. We are not concerned with explanation 1 to 3 now for the present. Explanation 4, where electronic record is created, stored in multiple files, each file is primary evidence. That already I have told you that it is created for the first time in the computer. It has taken birth in the computer for the first time. It is created. But it is stored in various components in the same computer or any other storage in the computer or any other storage that also partakes the nature of a primary evidence. Number 5 says that electronic digital record produced from proper custody unless it is disputed. As I have told you that what is meant by proper custody. So proper custody is not only the criteria here, but the custodian must have the primary evidence with him. It can be disputed in two manners. Number 1 is it is not a primary evidence. Number 2 is it is not from the proper custody. To ascertain whether it is primary document or not, you apply these principles. It is whether created, stored in multiple files. Where video recording simultaneously stored in electronic form and transmitted or broadcasted. For example, if you are watching a cricket match, it is transmitted, but recorded somewhere else. In Mumbai, the match is taking place. We are all witnessing. We also record that. If we record it in our mobile or computer or whatever you call it, if you produce that, whether it becomes a primary evidence. This says yes, because of the reason it is stored or recorded, transmitted everywhere, and there is no end point for this. Whether you record it or anybody record it, there is no end point for that. So therefore, if anybody recorded that also, for example, swearing ceremonies of the judges, you also record that. YouTubers, they will upload it, they will record it. They produce it before the court of law. So that type of evidence also falls within the category of primary evidence. So explanation 7 is, this is only applicable to video recording, not for any other type of evidence, electronic evidence. Well, the electronic or digital record is stored in multiple storage spaces in computer resources. Each such automated storage, the computer should automatically store it in various places in the computer. It may be in the hard disk or in one of the drive or in another drive, whatever you call it as, the places or spaces in different areas in the computer. If it is stored in different places, even though it is stored different places, all those different stored places, if it is produced before the court, that becomes a primary evidence. So the significance of this section 57 is that if it is original document that is produced before the court, there is no necessity of producing any certificate as such with regard to the contents of that particular document, because court itself can peruse that document, that original document, once it is admitted that it is original document. In such circumstances, no certificate is absolutely necessary. Now, transmitting and broadcasting, so sending the information without necessarily knowing whether anybody is recording it or not, through internet, various things will come to our knowledge. If that you have stored it in your computer or in your gadget, you can produce it as a direct evidence before the court. So electronic digital record, BSA section 61 says that you cannot deny merely because it is an electronic record, digital record in evidence, on the ground that it is an electronic or digital record, and such record shall be subjected to some other provision, condition, precedent to be followed. So therefore it gives an impression that if an original document is produced, the electronic evidence is produced without any certificate, you cannot deny that. Second thing is, if secondary evidence is produced before the court, then you can deny that the condition precedent is not followed, but you can say that merely because it is an electronic evidence, I am not denying to getting it, take it as a document. But I am only on the point that whether the other fulfillment is done according to law or not. So section 62 is a special provision which exhaustively dealt with by Arjun Pandit Rao's case, which says that electronic record, the contents may be proved in accordance with the provisions of section 63. So may be proved, the Arjun Pandit Rao case, that it shall be in accordance with section 63. So in this background, we have to analyze section 63 very carefully. So in various decisions, even in Anwar's case, in Arjun Pandit Rao case, it is said that section 63 itself is a special code. This notwithstanding anything contained, the non-obstante clause contained in section 63 gave birth to 4 judgments. Navjot Sandhu's case, Anwar's case, and Arjun Pandit Rao's case, Tommaso Bruno's case. So all these judgments interpreting the word may and also notwithstanding. Though the word may is used in section 62, Arjun Pandit Rao says it should be read as shall. Because of the wordings used in notwithstanding the word used in section 63. So as in the earlier, the speakers have said that in Navjot Sandhu's case, it says that even you can apply for the secondary evidence to be proved before the court the other provisions of the Indian Evidence Act, where it is an impossibility to produce the certificate or not produce, still the court wants to rely upon that document. It can admit the document. But in Anwar's case, these judgments have been virtually overruled and said that no, it is an independent code. Therefore, the compulsorily section 63 has to be complied with. If it is not complied, it cannot be admitted, subject to certain exceptions as stated in Arjun Pandit Rao's case. So in this background, we have to understand section 63 is only referable to secondary evidence where we find it should be a computer output. The original information is somewhere else, and that original information is fed to the computer and taken the copy, it is the computer output. That means, as I have already told you, that if it is created in the computer by yourself, that is the original. If you download it to any other multimedia, that becomes a copy. So if once the original is there either in the computer or in some other electronic record, some other electronic gadget, if it is fed to the computer and thereafter you take the computer output, that will become the secondary evidence. So how this secondary evidence can be produced before the court? Section 63 computer output means what? It is printed on paper, printouts from computer. For example, if you go to a mall, if you pay something, the computer receipt will come out. The computer receipt is already fed to the computer. The original will be in the computer itself and copy will be given to you. That copy you produce before the court. Computer printout. Whether it becomes original, you have that custody of that original document which is the computer output. So therefore, section 63 is equally applicable, that one has to say that how it has come from the computer, what has been fed to the computer and how it has given out. That is computer output. So or any communication device output like mic, keyboard, joystick, speaker, printer, monitor, etc., etc. So once the document is taken out or computer output and it is produced before the court, along with the certificate, though it is in the nature of secondary evidence, it becomes a deemed document before the court. Deemed original document before the court. The presumption with regard to the procedure to be followed once the certificate is issued. So what is the nature of the certificate that has to be issued? We will discuss a little later. So this, once the certificate is issued, it draws the presumption that the procedure is properly followed. Therefore, the court is at liberty to mark the document, because the procedure, the presumption is only with regard to the procedure, not with regard to the truth or otherwise of the contents of the record. It should be independently, separately proved. There I will tell you, I will come back to that case law, that the truth on the basis of which the police have filed the charge sheet and accused was convicted, that is recovery of jewelries at the instance of the accused. The truth was otherwise in the computer, in the secondary evidence, in the disk. According to the police, it was directly recovered from the hands of the accused. But according to that document, which shows that it was implanted to the accused at the place before it is being recovered by the police. Because the judge has not looked into that, he relied upon the statement of the witnesses and convicted him. If electronic evidence would have been looked into, the truth is otherwise. So therefore the contents, the information contained in the document has to be proved independently. What is presumed is the procedure only. The conditions to be fulfilled is computer or the device used regularly to create, store or process the information, the regularity of the user, the activity of the computer was proper and correct. The computer has been continuously, regularly used. If it is not regularly used for a particular activity, then it can be explained by the person who gives the certificate that though it was not at a particular point of time working, but it has not affected the data, it has not affected the output from the computer. The person having lawful control over the use of the computer or the communication device. The person who gives the certificate or the necessary information, he has to say that the person, I am the lawful owner. Whoever may be the person, the lawful owner of that particular. Here also the custody plays an important role. Lawful owner means he may be the actual owner, or through somebody he is authorized to handle that particular computer. So such persons also can give the certificate, not necessarily the owner of the computer, who handles the actual computer at the time of taking the output from that. Information regularly fed into the computer or device in ordinary course of the said activity. That means the information, every day you are doing some activity with the computer. Similar type of informations are already fed like that. So you are carrying your business just like bank statements. Bank is every day feeding in their daily activities, in the regular course of business that has been fed into. That means not it is abruptly fed into the computer for the purpose of manipulating or for the purpose of taking out the computer output. The operating properly, if not, the computer was operating, that's why it is, I said that it was operating properly, if not, explanation that it did not affect the electronic record or the accuracy of its contents. Those certificates should contain all these things. The information fed into the computer or device in the ordinary course of the said activity. Like that way, if the more than one computer is used, if the computer network is there or computer resource is there, intermediary provides, the service provider provides it. So if all the computers are interconnected with each other by means of network or system. If it is taken out, the computer output taken out in any one of the computers, it becomes the secondary evidence, because in all the computers, the same thing has been fed and in different areas it has been stored. The same, just like a bank statement. If you can take your bank statement even anywhere at your place. Your State Bank of India, if it is digitized, you can take the money anywhere in State Bank. You can operate your account from anywhere. So therefore, all those computers are interconnected with each other. So therefore, its certificate should also say that if several computers are used and they are interconnected with each other, in such circumstances, the certificate establish that particular aspect also. The certificate shall be issued in any of the following. That means the Supreme Court has clarified this. Any of these should be read as all. All in the sense at each instance. I have already told you, suppose if the chain of custody is changed, police officers, they have taken the output from the computer, a copy was sent to the FSL or examiner with all seal and protection, everything. He puts the same into his computer and downloads it, examines it, and thereafter gives the certificate. Again, it comes back to the police officer. He again put it, opening the seal and resealing for the purpose of getting the copies and giving it to the accused, etc. So the computers are changed here from hand to hand. So every instance has to be understood that wherever it goes, all those persons have to give their certificate with reference to the technical working of that computer properly, and the activity was proper, it was properly, activities were fed into that computer, information was in ordinary course fed into that computer regularly. So wherever it goes, the certificates may be multiple. Next is certificate at each instance and when the certificate has to be issued. The Supreme Court has now clarified in Anwar's case and as well as in Arjun Pandit Rao's case that it should be produced when the document is sought to be admitted in evidence. As I told you, if the certificate is produced along with the document, well and good. If it is not produced, at least it must be produced before the electronic evidence is admitted in evidence. The court has to be very careful. The question arises that in Sonu's case, the Supreme Court has said that if it is not objected by the other side, if it is not objected by the other side, then he cannot raise that issue before the appellate court. If it is not objected means what is the question? Whether court can object for marking of the document. Whether court can simply sit as a silent spectator. Whether you can admit any secondary evidence without any basis, without any foundation, let alone the electronic evidence. If some other document is produced before the court and it is a secondary evidence, it's a Xerox copy, suppose, if it is a Xerox copy of the same original. If the other side is not objecting, whether the court can mark it or it can stop it saying that lay the foundation first for the purpose of leading the secondary evidence. Whether any foundation is laid or not, whether it amounts to a condition precedent or not is the question. So if the court has not also objected or not looked into this particular aspect and got the document marked due to ignorance or any other reason, then only in such circumstances it cannot be questioned before the appellate court. So therefore there is opportunity not only to the party who can object for marking of the document, but the judge, if he finds that no, it is a secondary evidence, it cannot be marked without a certificate for the purpose of avoiding future complications, the court also can insist for production of Section 63 certificate. That is why in Arjun Pandit Rao's case it is said that if it is not produced before the court, under such circumstances, what the court can do? It can ask the party to produce the certificate, number one. Secondly, it can use its powers under Section 91, 165 of Indian Evidence Act, etc., under Order 16, Rule 6, Civil Procedure Code, for the purpose of getting that particular certificate. If in spite of that, court is unable to get the certificate at all, but in spite of that, if the court feels that the contents of the document is relevant for the proper adjudication of the rights of the parties, in such circumstances, a window is opened by the Arjun Pandit Rao's case that it can be admitted in evidence, but only after exhausting all these legal remedies available. Not that it is simply by exercising the powers under the various provisions. The judge has to satisfy that it is impossibility to produce the certificate. So nobody can ask to do an impossible act. If you know that it is impossible, so the court should satisfy itself that there is an impossibility, total impossibility, even in spite of exhausting all the remedies, then only the court can admit the document, even in the absence of Section 63 certificate. That's what Arjun Pandit Rao says. Here, the another important aspect to be looked into is that the certificate should be in a particular format. Earlier, these Schedule A, B were not there. Section A, Part A, it says that it should be given by the party. The content should be filled up by the party. So here, some of the persons may understand that who is the party. So therefore, it should be understood that the contents of the format is to be read as a whole. So underneath that particular certificate, it says that the owner, the person who maintained, the person who managed, the person who was operating. So all these persons are recognized as the custodians, proper custodians. It is the proper custody. They can give such certificate also. So next, Part B is very important. Here Part B is referred to an expert. Who is an expert then? Section 63 doesn't say or gives any explanation with regard to expert. Who should be an expert for the purpose of this section under Part B? Whether he can be equated with the examiner as contained under Section 79A of Information Technology Act. In my personal opinion, no. Because of the simple reason, every document need not be sent to the FSL for investigation. In civil cases, every document need not be sent. I have created a document, I have downloaded it, copied it, produced it before the court, I have given Section 63 certificate. So here, the owner who is not knowing about all these technicalities, how we can expect from him to give a hash value on other information. Therefore, he has to rely upon some other person. So therefore, it is said that the person who is operating regularly, feeding the information regularly to that computer in the ordinary course and taken the output, he is the proper person to issue the certificate. And expert means he should be a skilled person, that is sufficient. So far as for the purpose of this provision, if it is a skillful person who can give an explanation with regard to the procedure adopted for the purpose of feeding, for the purpose of taking the computer output, and how the computer was working, etc., etc. And he has seen the contents, and the contents are not modified or tampered. If such person who is skilled, if he gives such certificate, in my opinion, it would be sufficient. But Section 79A of Information Technology Act only applies whenever a particular document is sent for the examination. Sent for the examination, and the court has to form its opinion with regard to the electronic evidence, scientific information is required, then only Section 79A is applicable, and such expert should give the certificate, not in all the circumstances. So again, this part B is to be understood that the Arjun Pandit Rao case said that it is an independent court. Section 63 is an independent court. If you say that it is an independent court, it says that notwithstanding anything contained in any other provisions of this Act. So therefore, only we have to apply Section 63, whether Section 63 says that, sir, in another 10 minutes is there. I will conclude and thereafter. So then only what I was telling, that notwithstanding anything contained in Section 60, any other provisions of this Act, Section 63 alone is applicable. If you understand in such manner that whether Section 63 says that, who is an expert? If it doesn't say that, we have to apply the general principles, who is an expert. So earlier, Section 45 of the Indian Evidence Act and even 39A and B, 39A doesn't refers to any expert. Who is an expert, it doesn't define. But so far as 39B only defines that expert or the examiner as defined under Section 79A. So therefore, we have to analyze that any skillful person who can explain to the court that what he has done, Part B certificate can be given by such persons. Even to the extent I may say that the person who was competent to operate that particular computer, he himself also can give Part B certificate. If he is an expert or he is skillful person who can explain the queries of the court. So this is what exactly Section 63 says. And I have already told you that insofar as the impossibility is concerned, in one of the cases it happened that an accused committed rape on a girl. He recorded a videograph of that material in his mobile. He has taken copies of that, made compact discs, and served to his friends. And thereafter that computer, that mobile was destroyed. Mobile is not available at all. During the course of investigation, the police have seized that compact disc, which is actually a secondary evidence. They put it to their computer. What is here is secondary evidence is put into the computer and taken the output. That copy has been produced before the court. This was also produced, and the explanation has been given. So who has to give Section 63 certificate here? Because original has not been fed into the computer for the purpose of taking the output. So if you ask the accused to give the certificate, it will offend his right under the Constitution. So you cannot. The same example in another example, if a will is created and signed by a testator and he has taken the copy and thereafter he died, then who has to give the certificate? The copy he has already taken, that has been produced before the court. Where under such circumstances we can say that it is impossible for the purpose of directing anybody to give such certificate. So Arjun Pandit Rao says that there must be some person who is capable of giving that such certificate. If you find no such person and it is impossibility, in such circumstances, the court can pass judicial order while admitting that particular document, if it is necessary for proper adjudication of the rights of the parties. If the truth is there in the contents of the document, the court cannot shut its eyes. So the last leg is appreciation of evidence. As you all know, there is absolutely no difference with regard to appreciation of evidence, either it is a electronic evidence or any other evidence. But what I suggest is that what is placed before the court, some of the judges are not at all looking into the contents of the electronic evidence at all. They normally, in criminal cases, my experience goes to show that they look into the other evidence available on record, and the electronic evidence was not at all looked into in some cases. So in order to corroborate the evidence already on record, or in order to ascertain the truth or otherwise of the contents of the record, first you have to analyze the contents of the record. What is the content of that record, whether truth is coming out from the information containing in that particular electronic document. So that is, I think time is also up. We can keep it open for the August gathering. And I have prepared the paper also. And in fact, I have quoted almost all the decisions, even with regard to this impossibility and non-production, and thereafter this Sono's case, Tomaso Bruno's case, and all other High Court judgments are also I have quoted, and I will furnish it to your Judicial Academy.
I am hereby requesting to the Director Judicial Academy to provide the copy of the certificates to these judgments on email to all the participants. Okay. And I am thankful to Brother Fernandez that who has given an excellent deliberation on particularly evidence law. I am just adding only one line, that is BNS certain sections and the sections on which Brother Fernandez has added. Officials, police, please write down those sections only. Section 2A, audio, video, electronic means recognized under the BNSS. Section 2, subsection I, electronic communication, well defined, recognized under the BNSS. Section 105, now mandatory for you to recording search and seizure through audio, video, electronic means. 530 BNSS indicates that trial proceeding to be held in electronic mode, issuance of summon, execution of summon, warrants, examination of complaint, recording of inquiry, witness, trial, investigation, everywhere you have to apply it. And particularly about certification, my brother have said, initially there was no standard performer prescribed for the purpose of producing the electronic evidence under section 65 capital B. Now under the Bharatiya Sakshya Sanhita, the schedule indicates certificates, two types, certificate by person and certificate by experts. Brother have categorically indicated that the word certificate individual does not means non-official, official also. Let us suppose any person who is recording the evidence under section 105, certificate you please provide.
Operator.
One thing, operator, my brother is saying operator, one thing I just as from the angle of, because we have practiced as a lawyer, so lawyer wala kida hai dimag mein. So I have put one question to my brother, one question has come in my mind, because discussion, my brother has said that there are 2-3 situations. Let us suppose for inquest report police has reached, he has recorded everything, and the recording police has attached with the case diary. Whether for the inquest he will provide the separate certificate, number 1. Number 2, for seizure, separate certificate. Let us suppose in the meantime IO changed, so separate certificate should be issued, and subsequently at the time of conclusion of the investigation, the another IO is there. So whether the IO can provide certificates to the other IO who has not provided earlier. So I am of this opinion that those officer who has used his mobile and taken, let us suppose inquest has been prepared by one officer or one SHO or one IO, let us suppose the seizure has been made by another IO, then the IO who has taken by his own mobile, he should have to provide his certificate according to Bharatiya Sakshya Sanhita, that you please keep taken care of. Because let us suppose at the time of trial, the last IO will say that nahi uska bhi certificate hum diye, ye nahi chalega. That is impossible. So you please take care of that. Now it is an open session. Whatever be the question you have query, you please put. My brother and I myself try my level best. At least 2, 3, 4 questions you please put to us. Yes.
May I, with the kind permission of Honorable Lord, seek a question?
Yes, please.
First of all, my Lord, I have a specific and earnest request. You had discussed a particular case which you had authored and you had laid down 10 golden principles on the aspect of chain of custody. I could not actually take the citation, so if it is possible.
Citations shall be provided by the Director Judicial Academy. Don't worry.
The citation.
All right.
Citation will be provided.
There are 3 judgments on the same point. One by Delhi High Court and 2 from Karnataka High Court, with regard to the protection and preservation.
All right.
One is mine.
Please sit down. Please, another person.
Lordship, I had a question. This was
now you have, please.
Yeah. Lordship, I was reading this article of the senior advocate Karuna Nandi, wherein she raises a particular question, and she has relied upon 2 judgments. One is of Honorable Kerala High Court, Hakim versus State of Kerala, and then there is another of the Honorable Supreme Court, Sharat Babu versus Government of NCT of Delhi. Now, what the noted senior advocate says is that if it is a gruesome offence and it falls under the purview of both, that is under the IT Act and also under the Indian Penal Code, then in such a case, if the courts ignore the aspect of the IT Act and squarely convict the accused on the basis of the provisions of Indian Penal Code, then there is no problem. It is a classic case of socialistic justice, but it cannot be a case of legalistic justice. I was reading this judgment of the Honorable Justice Deepak Mishra in the light of this article, Sharat Babu. What my lord says is that since the case under section 292 of Indian Penal Code established, we need not go into the question of the IT Act. So my lord, my idea is not to question the wisdom of this, but the only thing that I wanted to know is that if there is a law and that is not applied, then what is the point of it, my lord?
See, when law says something has to be done in a particular manner, the courts are adhered to do that in a particular manner only. So if one court, if I don't know how that particular judgment has been rendered, is it not? Whether it is a gruesome or whatever it may be. If it is in accordance with law, then it is okay. If it is in violation of law, that can only be called as a moral judgment. It cannot be called as a legal judgment. Because administration of justice either on criminal side or on the civil side shall be done in accordance with law.
Yes,
so yes.
Yes, another question, please.
Pralam Lordship, my name is Ratnesh Kumar Dwivedi. I am from Munger Jaship. Lordship, I wanted to ask both the laws like BSA and BNSS time and again talks about introducing the provision that emphasizes the importance of maintaining the integrity, authenticity and proper handling of the electronic evidence, including measures to ensure a robust chain of custody. But meanwhile, I did not able to understand that since we do not have this any notional concept of having a digital data record room as of now at present. So what is the duty of us being magistrates, like if a particular police officer or investigator is
Officer, this law is presently growing.
Yes, Lordship.
So you are seeing this law that as an end result just now. It is just growing one.
Yes, Lordship.
You know
I just
that Government of India has prepared the DGCOM where you used to keep the record. Definitely there shall be a forum on which record shall be preserved, and Government of India is preparing on that.
Yes, Lordship.
So this question is presently irrelevant, but definitely after 1 year this question shall be definitely irrelevant.
Yes, Lordship. I just wanted to know what would be our duty as a magistrate, because as Lordship stated that जैसे कि कोई भी investigator कोई अपने
आपके पास डॉक्यूमेंट लाते हैं उसको प्रिजर्व करके रखिए. It is your duty, you preserve it.
किस मैनर में, मतलब
जैसे आपको रखना, जैसे मान लो सीडी आया या आपके पास पेन ड्राइव आया, उसी रूप में रखिए.
No, that is why there are 10 guidelines.
Yes, Lord.
It is laid down by me and even other high courts, Delhi and other high courts. So you go through those guidelines,
yes, Lord,
and preserve it. It should be preserved till the logical end of the case.
Please, from police side.
Okay, thank you, Lordship.
Yes. दीजिए माइक दीजिए माँ.
Jai Hind, sir. I am Himanshu Kumar, DSP, Muzaffarpur Cyber Crime. Sir, in Muzaffarpur, approximately 500 to 550 complaints are registered every month, and all complaints cannot be transferred as FIR. So my question is, there are some transactions, like just 1 year ago, in Muzaffarpur, a businessman who has a business of lychee. So by mistake, that man has transferred to someone else 10 lakh rupees. And it's been 1 year since this is a non-cog offense. But I met the Judge Sahab there, and he told me that they cannot pass an order to revert back the money without filing an FIR. But sir, since in Honorable High Court of Punjab and Haryana, they have ordered the district police that they can revert back the money just by entering in station entry, they can revert back the money. But can we expect from the Honorable High Court of Patna to pass similar order to district that without filing an FIR in non-cog offences, money can be transferred back to the victim account? Because sir, the very purpose of everything is that if we want to provide justice, then we can't. If we can't provide money back to victim account, there is no point of doing all these things.
Please sit down.
Thank you, sir.
Whenever a statute is very much clear, being the officers and being everyone who is living in the country has to follow the rule of law. So if a statute is very much clear, you have to follow it. If a judgment has come on this judgment is for that particular state and it is not for your state. And so far as you want a judgment from the High Court, so courts used to pass judgment only when the matter used to come before the court. When your matter will come, court will pass the order. But presently, the guideline for you that you follow the rule. If in non-court case, you follow the provision. In non-court case, you have to take permission from the court. You will take permission from the court. What is bad in that? Please.
No, so far as your question is concerned,
Sir.
without there being FIR lodged to the court, whatever you have done, the investigation, that is what we call it as a preliminary investigation. During the course of preliminary investigation, what the court can pass an order. Court gets jurisdiction only after lodging of the FIR before the court. Even inquiry starts from that place. So there is no inquiry, trial or anything before the court. So you are the master. You are the master. You have to take the discretion either to return it or to keep it till the conclusion of that particular investigation. So then if anybody objects for that, either you can go to the High Court or to the other party can go to the High Court. Then only High Court can look into whether any amendment has to be brought in to that particular enactment. So as my brother said that, if statute doesn't provide any remedy, you cannot have any remedy.
Sir, but since if offense is non-cog, then like there are so many amounts are pending in the bank, accounts are being held, and money is left there, business are disrupting at large numbers, sir. And if like honorable courts can also go for suo motu, and we are also requesting.
Please read the statute minutely. If offense is non-cog, then also you have to do something. Police has to do something or party has to do something.
Yes.
Without filing application, definitely you cannot even do any inquiry.
Sir,
So in case of non-cog, you read the provision very minutely and discuss the thing with a public prosecutor of yours. That what you supposed to do and you do, definitely court will take cognizance and order will be passed. But you don't do yourself from your side. Because if law indicates that in non-cog case there is a specific provision, you follow it. Yes.
Thank you, participants, for such a proactive participation. We have just now witnessed a very eloquent and a very detailed presentation of all the aspects relating to electronic evidence, which includes collection, preservation, and how to present it before the court of law. We have also heard the legal aspect, and my lord has also dealt about in the scientific aspect of the electronic evidence. So we thank both the lordships for detailing this electronic evidence and for exposing the entire aspects of electronic evidence. We hope and we believe that all the provisions that have been laid threadbare will be used by all of us, the police officers in their investigation and all the judicial officers in their analysis of electronic evidence when it comes before them. So thank you, Lordship. Thank you so much for this enlightenment, fourth and the final session. Thanks, my Lord. Please, a hand of applause for Lordships.
Very fantastic deliberation.
With this, we come to the penultimate session, penultimate part of this whole one-day conference. To sum up and to deliver the valedictory address, I now invite Learned Director Sir Sri Purushottam Mishra, Director Bihar Judicial Academy. His insights will help us to together the complex legal and technological themes that we have explored throughout the day. Director, sir.
Honorable Mr. Justice Ashutosh Kumar, Acting Chief Justice, Patna High Court, cum Patron-in-Chief, Bihar Judicial Academy. Honorable Mr. Justice Vipul M. Pancholi, Judge cum JD1, Patna High Court. Honorable Mr. Justice Pawan Kumar Bhimappa Vajantri, Judge cum JD2, Patna High Court, cum Honorable Chairman of Bihar Judicial Academy. Honorable judges, other honorable judges of Patna High Court, esteemed resource persons, learned Registrar General of Patna High Court, learned officers of Registry, learned officers of Judicial Academy, learned Principal District and Session Judges, and other judicial officers, DSP Cyber Police Station from all over Bihar, and other distinguished participants. Please accept my sincere and warm regards. Good evening to everyone. I, Purushottam Misra, Director, Bihar Judicial Academy, deem it a singular honor and privilege to address this august gathering. At the very outset, I wish to express my profound gratitude to Honorable Mr. Justice Ashutosh Kumar, Acting Chief Justice of Patna High Court, whose unwavering support, visionary leadership, and mentoring presence have been instrumental in conceptualizing and actualizing this one-day seminar. His Lordship's continued guidance has served as a beacon for all of us. My Lord, Greek parables and second was a spell of magicians, along with parable given by our honorable resource person, Honorable Justice K.N. Fanindra, give us lesson to update ourselves, learn and spread information and skill. I am equally indebted to Honorable Justice Vipul M. Pancholi, Judge cum JD1 Patna High Court, for his constant encouragement and inspirational involvement in our endeavors. His Lordship's insights have continually motivated us to strive for excellence. This conference owes its very genesis to Honorable Mr. Justice Pawan Kumar Bhimappa Vajantri, Judge cum JD2 Patna High Court, and Honorable Chairman of Bihar Judicial Academy. His Lordship has been the visionary architect behind this academic engagement. Without his meticulous guidance, conceptual clarity, and steadfast encouragement, this conference would not have come to fruition. I express my deepest gratitude for his invaluable mentorship. I am further thankful to the esteemed Board of Governors of the Bihar Judicial Academy, whose support and oversight ensured that this initiative saw the light of the day. My special the invaluable role of the learned Registrar General of Patna High Court in the successful execution of this event is also very noteworthy for me and my team. I quote, in the successful execution of this event cannot be possible without learned Registrar General guidance. I also place on record my appreciation for the sincere effort of the officers of registry and the academy, whose dedication and diligence have contributed significantly to the seamless organization of this conference. Today, we have provided one pen drive in which almost all relevant case laws from Afsan Guru, P.B. Bashir, as well as Arjun Pandut Rao Khotkar, and on the judgment of Honorable Delhi High Court has been also put in that pen drive, and that has been prepared only with the constant and regular effort of officers of directorate. My Lord, this scholarly conclave has been intellectually invigorating platform that has facilitated comprehensive discussion on a wide array of critical issues, from the evolving landscape of electronic and digital evidence to legal and ethical dilemmas posed by cyber offenses, data privacy, and the architecture of cyber law. Each theme was explored with admirable depth and analytical rigor, The sessions were thoughtfully structured to offer both theoretical insight and practical applicability, thereby bridging the oft-cited chasm between jurisprudence and judicial implementation. A substantial body of landmark and contemporary case law, both from Indian and international jurisdictions, was deliberated upon, offering participants an enhanced understanding of the jurisprudential trajectory governing digital evidence and cyber jurisprudence. I will pause for a moment, and I would like to discuss one important case on the point of law of contract section 4 that was discussed way back in 1959 in Bhagwan Das Kedia case that was related to instantaneous communication, and that says where contact will be concluded. So I think that law is still relevant for us. These discussions not only expanded our legal consciousness but also equipped judicial officers with sharper analytical tools to engage with the complexities of the digital realm. This conference has illuminated and multifaceted challenges and latent opportunities embedded in the digital era, particularly in the context of adjudication and justice delivery. It has deepened our collective understanding while fostering a renewed sense of responsibility to adapt to this evolving legal paradigm. I remain hopeful that such academic and professional engagements will become a norm rather than an exception, and that we shall continue to foster a culture of continuous learning and judicial innovation. Thank you all for your patience and present attention. Jai Hind.
Thank you, sir, for your reflection. As we draw curtains on this program, may I now request Sri Vinay Shankar, Additional Director, Bihar Judicial Academy, to propose a vote of thanks.
With highest regard and humility, I, Vinay Shankar, Additional Director, Bihar Judicial Academy, wish a very good evening to all the honorable dignitaries and respected participants. I am fortunate enough and feeling immense pleasure to propose the vote of thanks at the conclusion of one-day conference titled Understanding Electronic Evidence and Cyber Law, Implication under Indian Evidence Act, Bharatiya Sakshya Adhiniyam, Digital Personal Data Protection Act, Information Technology Act, and other relevant law and landmark judgments. The subject of today's conference is of utmost significance in the changing dynamics of crime, investigation, as well as adjudication. We are sure that the view shared on the topic by the honorable dignitaries and the learned luminaries will illuminate and enlighten the curious brain, and the impact will be seen and feel in investigation as well as in adjudication. It is my honor and privilege to acknowledge the blessings of Honorable Mr. Justice Ashutosh Kumar, the Acting Chief Justice of Patna High Court, cum Patron-in-Chief Bihar Judicial Academy, with utmost gratitude. His Lordship mere presence exude positivity and energize the brain. I owe my gratitude to Honorable Mr. Justice Vipul M. Pancholi, Judge cum JAD1 Patna High Court, a source of inspiration and discipline, for his kind presence and blessing to all of us. I express my sincere gratitude to Honorable Mr. Justice P.B. Vajantri, Judge cum JAD2 Patna High Court, cum Chairman Bihar Judicial Academy, who has not only given the entire idea of this conference, rather guided us on every occasion to make it happen. I express my deep sense of gratitude to all the honorable judges of Patna High Court, cum patrons Bihar Judicial Academy, who has chaired the dais, as well as who has participated in the program of the dais and blessed us today and graced this occasion. I express my gratitude to Shri P.K. Sahis sir, Learned Advocate General, Government of Bihar, for his kind words and blessings. I express my deep sense of gratitude and render thanks to Honorable Mr. Justice K.M. Fanindra, Up Lokayukta, State of Karnataka, and former Judge of High Court of Karnataka. The Academy will remain indebted to His Lordship for sparing valuable time for this conference and enlightening the participant on the subject matter of today's conference. We are very fortunate that the participants have got the opportunity to listen to Professor S.B. Joga Rao, practicing advocate and former professor of law of the reputed institute that is National Law School of India University, Bangalore. We have also got opportunity to listen and appreciate Dr. A. Nagaratna ma'am, Associate Professor of Law, National Law School of India University, Bangalore. The Academy will always remain indebted and owe its gratitude. I express my gratitude and render thanks to respected Registrar General, Sir, of Patna High Court for his unconditional affection and guidance. I owe my sincere thanks to all the respected Principal District and Sessions Judge, Bihar, respected Member Secretary of Bihar State Legal Services Authority, the officers of the Registry of Honorable Patna High Court, officers of the Bihar State Legal Services Authority, all the judicial officers, all the police officials present here for their active participation in the program and make the program worth and meaningful. My sincere thanks to all the officers who has participated in this program in online mode. I owe my gratitude to Shri Pranav Sankar Sir also, Registrar List Patna High Court, for his kind gestures to the Academy and academics itself. My sincere thanks to our Director Sir, who led from front and guided us. I owe my gratitude to all my fellow officers of Bihar Judicial Academy, who continuously put their best effort to organize the conference. I also thanks to all the officers and staff of the Academy, as well as other agencies who involved in making this program a successful. I once again express my gratitude and render my humble thanks to their Lordship for sparing valuable time to bless us and grace this occasion. Thanks to one, everyone, and all. Thanks a lot, and pranam.
Thank you, sir. With Lordship's permission, we may end this program. We conclude this program, and there's a small announcement. We'll partake snacks as a part of a high tea after this, immediately after this program. And for this, we have separate arrangements. Lordships will be there in tutorial 1. And as far as officers are concerned, they will partake their snacks in the mess. And the police officers who are present here will partake their snacks on the left-hand side, that is in the cafeteria itself. So with this, I formally thank all the honorable judges, all the dear participants, and all the police officers who are present here for the day-long deliberation. Thank you so much for your patience listening and for active participation. Thank you so much.